Yes.
Adjournment request, if any, from item number 1 to 8. From item number 12 to 24.
With the consent of petition, it means item number 13 and 14, my lord. Advance.
Circulated the slip. All right.
18 August.
May I please lordship, my lord, I victimize item number 12, my lord.
Yes.
To file petition. Hello.
All right.
20th August, 20.
May I please, your lordship? Lordship, consent taken from the opposite party, lordship. I beg to mention item 22, lordship.
Adjournment slip again. All right.
20th August.
22.
Any other request?
May I please, I would like to mention an item for listing, my lord. Tomorrow we have filed a writ petition on 2nd. My lord, there is some urgency, my lord. The contempt has been filed against that order. My lord, I am praying for tomorrow. my lord.
Comply with that order. Otherwise, the case will be listed. Comply with the order. What is the order?
My lord, we are challenging the order.
What is the order?
What is the order?
My lord, the financial upgradation has been granted by the my lord,
Financial upgradation.
upgradation, my lord, ignoring the fact that a vigilance case was pending against the employee.
It's nothing urgent. Anyway, Monday.
Monday.
No.
Supplementary list, item 25 for orders.
May it please your lordship.
Yes.
This is a review application seeking clarification of the order passed on 27 November 2025 in respect of the eviction issue relating to PROCEEDINGS Medical College, where lordship was pleased to upheld our eviction process, eviction notices, everything, but there was a rider in that order which says that their case should be considered a phrase on the point of 4 principles under the settlement laws and land policies of the state. And 90 days outer limit was given. That exercise we have done. And now nobody has any rightful claim according to us, and a speaking order has also been passed.
You have passed the speaking order.
Yes, Lordship, that is also part of the record in our additional affidavit. Now, in that view of the matter, Lordship may be pleased to review the order dated 27th of November, in specifically in paragraph 64 of them, paragraph page 94, paragraph 68. 67, 68, Lordship may see, and Lordship also may be pleased to consider paragraph 62, where this honorable court very clearly said, for the reasons recorded herein above, this court therefore finds that while the eviction notices and reservation of land for medical college are legally sustainable, the question of rehabilitation has not been duly and fully addressed. The state as a model employer entity cannot push citizens into homeless, etc. Now, 64. Consequently, while upholding the validity of the eviction, this is what I am stressing upon. This court directs the state office, more particularly Principal Secretary of the Government of Assam Revenue and Disaster Management, and the Deputy Commissioner Kamrup to undertake a fresh individualized assessment of rehabilitation claim of each of the applicants strictly in terms of the Assam Land Policy 2019, Settlement Rule 1986. Such assessment should involve proper verification of landlessness, indigenous status, socio-economic vulnerability, and absence of an alternative accommodation. Therefore, in the fitness of thing, it will be appropriate to direct the respondent authorities, more particularly the Deputy District Commissioner, to consider this aspect of the matter while carrying out the exercise directed herein above. In addition, it is directed that while carrying out the exercise directed herein above, the claims raised by the writ appellants of so-and-so regarding status of DAG number 97 also be considered. The exercise should be completed within 90 days. Taking note of the submission of the Advocate General, the construction of the hospital is already completed and land occupied by the appellant is required for future expansion and for ancillary activities. In our considered opinion, ends of justice would be made. if it is provided that till such determination is made, no coercive steps shall be taken to demolish the existing dwelling houses of the appellants. So I am praying for reviewing of this order or
No, no, but,
clarifying, clarification.
Mr. Advocate General, would there be a requirement of review now?
It only clarifies because
It only
everything is.
requires, because see, the direction is that paragraph 65 speaks about the intent.
Lordship.
It says therefore, in all fitness of things, it will be appropriate to direct the respondent authorities, more particularly the district commissioner, to consider this aspect of the matter.
And that has been
namely-
considered also.
Correct. This aspect of the matter while carrying out the exercise directed here and above. Landlessness, proper verification, indigenous status, socio-economic vulnerability, all right. That you've done by a speaking order. The exercise shall be completed within a period of 90 days from today.
We have
That's
done it, so therefore this 68 may be removed now.
No, 68,
There's no
68,
coercive measures.
correct, 68 is invoked, 68 gets triggered only if you have not done that exercise.
We have done it, Lordship.
So therefore, it doesn't get triggered.
I leave it to your Lordship. If Lordship
We will
clarifies
clarify
that.
that.
If Lordship clarifies, then I have no objection.
Because it doesn't, you have done what the court has asked you to.
Absolutely, Lordship.
53, about that, appellant. Yes, yes, ma'am.
Lordship, after passing this order of the Honorable Court, my lord, no hearing took place. The hearing was earlier before the judgment has been pronounced. Hearing took place on 18/2/2000.
No, Mr. Chaudhary, look
Yes,
at,
ma'am,
look at this.
2026.
Mr. Chaudhary, we did it
Yes, my lord.
only for the purposes of giving you a breathing space.
Yes, my lord.
Let us
Yes,
let us be very clear on this.
Yes,
Now,
ma'am.
can you come to paragraph 53 of the judgment?
Yes, my lord.
My brother has just pointed it out. The judgment authored by him, therefore he knows every paragraph. Come to paragraph 53.
Yes, ma'am.
Read it out aloud.
Yes, my lord. As above the appellant, except the appellant WAPC number 3/11/11/2020, except me, my lord.
Yes.
Yes, my lord. Themselves have admitted the land are.
Therefore, we have asked you to read paragraph 53.
Yes, my lord.
Correct.
Humble submission is that, my lord.
Read it first, no?
Yes, my lord. Paragraph, my lord,
53
53.
and then
The
57.
appellant except are the appellant 311/2020 themselves have admitted the land are occupying has already reserved for TB hospital / construction Pagjotispur Medical College. In our opinion, they cannot have any bona fide claim for settlement land that they are occupying. Therefore, issuance of notice 18(2) cannot be set without jurisdiction. Now, coming to the argument, Mr. NNB.
Then go to 57. This is your case, 57.
7, my lord.
57 now.
Yes, my lord. That being the position opinion, the appellant cannot be settled land, they are occupied under Rule 16 settlement rule, clause 14 of the land policy. Therefore, court neither can term speaking order passed by the deputy nor notices issued under section 8 as illegal. However, speaking order passed by the deputy commissioner through procedurally valid does not reflect comprehensive inquiry determined as a requirement for the reliable individual petitioner. Clauses 14(3) and 14(4), nor it does not indicate individual factum regarding whether appellant are landless, indigenous, eligible for illegal benefits.
So the question is this,
Yes.
at any rate, you cannot be settled in that hospital land. Now, next question remains is your further settlement.
Yes, ma'am.
That they have rejected.
May-
Now you cannot allow to continue in that hospital. That is a final decision, not only here, before the learned single judge. Learned single judge clarifications, you don't have any right.
Lordship is correct, but Lordship kindly allow me submit to 2 minutes.
We are not changing the tenor of your judgment, not at all. We are only clarifying that paragraph 58.
Yes, ma'am.
We will clarify that paragraph 68
Yes, ma'am.
gets triggered.
Yes, ma'am.
It would have been triggered if they would not have carried out that exercise of considering your claim for resettlement. Now, suppose the authorities find that you're
My lord, they are not, the fact is that they are not carried out exercise as per direction of this honorable court. That is why.
where is that
Yes,
direction?
my lord. Yes, I am coming, my lord. Your lordship kindly go to the, my lord, this, my lord. I file a request before the authority. Important, my lord,
No, no, no.
my lord.
See, if you have an order against you, you can question that. But so far as this judgment is concerned, look at this. We gave you 6 months only for the reason, and we gave the state also 6 months to get active. Just a minute, Mr. Chaudhary, we understand
Yes.
you are being evicted from that place. We understand the predicament. We understand the
Yes,
trouble. But try and understand our limitations as judges
sir.
and try and understand the limitation of the state.
Yes, ma'am.
You may or may not, but there's a viewpoint which you must hear.
Yes, ma'am.
Now, this is a land undisputably, this was reserved for hospital.
No, my lord.
That is
Because-
the conclusion you got.
Yeah, that is conclusion,
Then
ma'am.
why you
Sorry.
say no?
Sorry, my lord.
His own admission is there.
No, my lord. My admission is
No,
not
no, you
okay, my
cannot
lord.
admit it.
This is your
This-
conclusion.
This is the conclusion of this case which cannot be interfered in a review.
Yes, sir. Yes, my lord.
It cannot be interfered in a
Yes,
review.
sir.
Let us go scientifically.
Yes.
Now, that land was used for construction of the hospital.
Yes, my lord.
Rest of the, forget about you, rest of the respondents here, they were in occupation of the land on the nearby parcel.
Yes, my lord.
That land was needed, that was a government land that was needed for construction of other administrative buildings for the efficient running of the hospital.
Yes, my lord.
Now, with the commissioning of the hospital, there is a great footfall. And in order to control that load, the other administrative buildings have to be constructed. Various other departments have to be constructed.
Yes, my lord.
We halted that process, though we ought not to have. We halted that process for 6 months just to ensure that persons who are landless may be accommodated in some other place, not in that place, definitely. Nobody can, not even, I mean, we do not have the powers to have you settle on that land which is reserved for, hospital.
Yes, sir.
So far, so good. It's clear. There is no difficulty.
Yes, sir.
Now, when we gave 90 days time to the state to consider that, on the ground of landlessness and other things, societal interest to be kept in mind, they have rejected it. You may not be happy with that decision, but you challenge that decision. But can they be stopped from vacating the land for the purposes of construction? That's what this review means. I mean, we will say that it is not required to be reviewed. It is only required to be clarified. It's not even a modification.
May I submit, my lord?
Yes.
My-
Now,
my
now we
hum-
have told you, you can
Yes,
submit
my
now.
lord. My humble submission before your lordship is that whether the government properly clarified the order, properly, my lord, carried the order, that is the crux of the issue, my lord. Because when they have issued a notice to me, I immediately, by following this order of the honorable court, I have given that, my lord, representation. Your lordship kindly go to the represent. That is the important thing. My lord, because, my lord, both parties should come with clean hand, my lord. That is important, my lord. And I say in that representation before the authority, my lord, what they have said in respect of Mormil Boro. Mormil Boro is an indigenous citizen of Athar. He's from Boro community, my lord. The state were rejected the claim of all the petitioners, but like that. He is a Boro person, my lord. He is landless person, my lord. Everything is there as per earlier Kobula filled up. And your honorable court has directed that you prepare the Kobula first, give the Kobula, it will be filled up, and thereafter you take the decision. Your lordship kindly come to the, my lord, my representation, my lord. I have also stated that paragraph also. 2, my lord, para 2, my lord. You talk with this one, huh? May I pray? Honorable Court issues specific directing where the settlement of the land status DAG number 90 directly pertain the claim. Honorable Gauhati Retable 311 is in addition to this. Lordship kindly come to directly 69. In my petition also I mentioned my paragraph 69. Page number 2. While parting with the record, we notice that yet another aspect of the matter, the prescribed format, the affidavit required to be filled when a citizen apply for a settlement of government land, do not include all information which require consideration at the hand of the state in terms of land policy, absence of which may create dispute as has arisen in the instant case in the present affidavit. Therefore, in our view, such affidavit format required to be application required for substantive improvement or the including all the essential conditions for settlement government land in which the policy
This was-
2019 to arrive that decision.
Correct, Mr. Chaudhary.
One thing is that if you also go to the speaking order, my lord, although my lord, yesterday evening I got the WhatsApp, my lord, I'm happy, my lord. From tomorrow, I also give the copy through the WhatsApp, my lord. Because if I give the three copy for 5 respondents, they are not accepting it. I'm happy, my lord. You all also kindly come to this. Yes, my lord. Ah.
Mr. Advocate General, you will not be able to refuse that WhatsApp delivery of affidavits henceforth, and we shall not also insist. If you do it for Mr. Chaudhary, you can't expect a better response. Yes,
Yes, my lord. If your lordship go to the, my lord, that speaking order, my lord,
yes.
where the, in respect of Monmil Boro, my lord, have your lordship got it, the speaking order? I have a photocopy.
You
of
can
the-
give us the page number, or you can
Yes,
tell the number of.
the speaking order. They have annexed in the additional affidavit also, my lord.
Mr. Bapujari, his Monil Boro.
147, my lord. I mean, it's a part of the additional.
Yeah, that's right.
147.
There are 26 defendants. There are 26 number of.
My lord. Where the Honorable Gauhati High Court did appeal 311 directed the undersigned to undertake fresh individual assessment of rehabilitation claim each of the claims strictly in terms of land policy 2008. Your lordship has directed to fresh, my lord. Land policy and settlement rule under regulation. Such assessment will involve proper verification, landless, one important indigenous status, socioeconomic vulnerability, and absence of alternative accommodation. Earlier in Kobulat Nama, your lordship know very well, remember, that is not available, my lord. Accordingly, Court District Commissioner, New Guwahati Court District directed Circle Officer so-and-so to undertake the individual assessment of real claim each appellant strictly. Whereas Circle Officer is the notice to Monmil Boro 18 to 2026. That notice, prior notice, my lord. And the
To be allowed to stay here.
yes, yes. 18 to submit adequate document.
Mr. Chaudhary, tell me one thing. I mean, no, we have understood all that.
My lord.
What do you advocate? Mr. Chaudhary, we are almost ad idem on this, the bench. We can ask the state to reconsider your application only on the condition that you vacate that place. Because for your interest, the larger interest of people, there is immense footfall. That can't be stopped.
My lord.
Now, 6 months, we find ourselves to be completely limited in our exercise of power for halting this process beyond 90 days.
My lord, by humble submission.
You can ask for some kind of a concession that you vacate, it shall be reconsidered and you shall be intimated. But that place must be vacated. You can't come as your settlement there. See, social interest is all right. We are all for it. Had it not been our intent and the motivating factor for delivering this kind of a judgment, we would not have said so. Once we justify the eviction drive, and once we hold, rightly or wrongly, which has not been questioned up till now, once we hold that you do not have any authority to stay on the land which is reserved for hospital or for any purpose government land, then stopping the process of further construction for 6 months, I mean for 90 days, that's
Then
3 months. I mean, this is something which is beyond our remit.
Hmm?
Now we can ask, subject to Mr. Chaudhary giving a positive, response.
I
that-
take instruction from my client.
No. This we will not wait for long. You say that we will give you, but you must vacate. It shall not happen. We can't allow this to happen in reserve. Let us be very clear. In reserve forest, we are not interfering. Come what may. Come what may, because we are under. Just a minute. We are under a legal obligation. We are under a societal obligation. We can't pass an order. You keep squatting on the land, we can't help it, but judicially we will not support that. In a reserve forest, in a government land, which is about to be used for construction of public buildings, hospitals, schools, panchayat bhavans. We will not use our powers to do this. Now, how much difficulty you may face, which was not out of our mind. Therefore, we gave 90 days. And we want you to be settled. But there is a limit to the largesse which a state can be saddled with. You know, the land is scarce. You don't get land by reclamation. It's not somewhere near seashore where the land is reclaimed. Nothing. So asking by a judicial order to allow you to live in a land which is meant for hospital construction, I don't think there is any law which gives us that authority.
My lord,
Therefore, you have to vacate. We can only give you this concession. Now, you don't have to take us. We don't need your concession there. Therefore, no necessity of taking instruction from your client.
my humble submission before.
Just
I
a minute,
cannot give the
listen to it.
consent.
Listen to it.
Okay.
What we intend to do is this. If they would not have done that and they would have made you vacate that place before concluding this exercise, you may not be happy with the way in which the exercise has been concluded. But that is different. That is for your settlement. Question is that here you must vacate. There can be no cavil about this. You say this, we will ask them to reconsider your views. We can, though of course this will not be the subject. This would be something again beyond our remit because we are hearing a matter for review. It is not required. It would only be clarified.
My humble
But we can make a parenthetical statement while clarifying. In parenthesis as a side swipe. You understand what we mean? That in case you're aggrieved, you can challenge that order. In case you're not aggrieved, we can ask the government to reconsider. But then there will be a precondition that you vacate the premises,
My lord,
or else you will be
my humble
evicted.
submission before your lordship, my lord.
Yes.
If I give the consent here, my lord, without discussing with my client, my lord.
No, don't give consent, no.
Yes.
We will, if you want that your things should be reconsidered, we can we can say on our own. We don't require your consent. We don't require consent of Mr. Chaudhary's client for the reason that we have no judicial authority and no judicial remit to forestall the process beyond this period. Try and understand. No matter how sympathetic we may be, can we do that? That's the question. I put a question to myself. We will be doing it with a heavy heart, but then what to do? We can't allow, patients not to have space for them to come and get themselves treated. That's equally important.
My humble submission before your lordship is that, my lord, I am on impression that because they are not preparing the Kobula, I am asking for new Kobula as per direction of the honorable
Then
court.
you,
They are
then
not
why
following it,
don't
my
you,
lord.
why don't
And
you,
there are
why
two
don't
persons, my
you,
lord. May I
why
complete,
don't
my
you
lord?
ask the government to review that decision? But before that, if we have to tell the government to reconsider, we will be asked, we will take that as a precondition that you vacate. We will say that.
My lord,
You vacate and they will try.
my lord,
Mr. Chaudhary, the first writ petition, same finding that you don't have any right, first writ petition. Then only it was sent for that notice was not given and you will give a reply first. There it was already decided that you cannot be settled in that land, this is a reserved land. And as per the settlement rules, no person can be settled where already earmarked for reserve. Second writ petition, same thing happened. Third writ petition, we have given you a leeway. This far and
I am
further.
not arguing on the, my lord.
In
judgment because
fact, there would have been no occasion for the state to even have a clarification. Our orders have been complied with, finished.
may I
The
submit-
question is that we are considering your case. After all, we are humans, and we are
Now, my lord, if we
considering
vacated
about the
today, my
society.
lord, I have become like a footpath dweller. So I have no other alternative of land, my lord.
Mr. Chaudhary, it is very difficult to counter that argument.
Yes, my lord.
If that argument
And
is made, if
there
that
are-
argument is made
yes, sir.
before you, you will be finding it very difficult to stop that. See, poverty should not be made use of. I mean, should not be made fun of. Should not
Yes,
be
my lord.
should not be unnecessarily stretched beyond a point. There are certain limitations.
Yes, my lord. My lord, my humble
We
submission-
understand that. Therefore, we are going slow in the matter. Didn't you see? The best option for us was to dismiss your writ petition, no? The appeal. The matter ended because the materials available before the learned single judge was that this is a land which is owned by the government. Government wants to construct and reserved. Reserved for hospital. Hospital has been
Then
constructed, not the.
2% were
Wait a
settled.
minute. So
Modern
the
discharge
best
got
option,
into
the
that
best
point.
option therefore
In
for
the past.
us would have had been to dismiss your appeal only on that ground. We went miles ahead. We
Yes.
gave you breathing space so that you might find out some place. This, if the state would have challenged this order, perhaps that observation would have been expunged. How can it be done? What authority do we have to allow settlers on a government land, on a forest land, on a land which is reserved for something else? I'm putting it in a different way. So this is the space which we gave you. Somehow the other it didn't work affirmatively for you. What do? We have no other option. In that circumstance, we say that the government might consider, reconsider your claim, but that observation will come only when you give an undertaking that you will vacate immediately.
That undertaking, I cannot give my lord here right now, my lord. Because next time, my lord, government has said your lawyer has given undertaking. That will
Then you
problem.
give an undertaking, we
That's
don't
fine.
even say that. We don't give an undertaking. We will say in case they come up before the state may consider, the state may reconsider.
Yes.
But it shall ensure that the premises is vacated. That we will say, it is not your undertaking. It is our. Yes, Mr. Advocate General. Any problem with that?
No, I have no
One thing
difficulty.
is
In fact, if we dig further, he will be trouble of committing fraud also. I'm just
No.
saying only one line.
No, Mr. Advocate General, please
We
don't.
have to redo it also. We are ready,
Please
but we will be in deeper trouble.
Please don't trouble them further.
Yes.
The question is this: they are settlers for land because for a long time they were allowed to stay there.
That long time is disputed. That long time, he has given a fraudulent document to claim that he is there from
We
1992.
don't do that.
In fact, from
We
2007,
won't
he has
get
the
into it.
actual
This order becomes suspect then. This order becomes suspect and highly challengeable. What is this? We are approving the eviction drive. At the same time, we say that don't evict. I mean, this is something which we have done beyond our remit. Mr. Chaudhary, try and understand.
6 months. is it?
Right.
Article 226 cannot be stretched beyond a limit.
May I
We are feeling very sorry.
Yes.
But क्या करें?
We
मेरे
tried
हाथ
to
बंधे
do
हुए हैं।
something.
करें क्या?
One thing is
If
that
I had my way, I would
the
have said that
landed
no
trade has
hospital.
said, always
let
said
it
they are
go.
committing
Law
fraud.
doesn't enjoin
these
us.
26 persons, all the 26 persons are not indigenous people of Assam, my lord.
That is,
That
cannot-
is same, my lord.
We have
Can
said
we-
individual.
They themselves has admitted,
Can
I am
we
from
arbitrate
Vaishali,
this?
I am from Darbhanga.
How can Boro person from Daisali, my
No,
lord?
no,
And this-
the other 26 persons.
Can the issue be arbitrated here?
And Boru person is also from a nearby area. If you dig, he will be in deep trouble.
We will not get into
not
that.
Yes,
We are not doing that.
He is from
We are not
88.
doing that.
उसमें जाएंगे कहाँ हम? Breathing space आपको दिया. It was not for
He
claiming.
submitted a fraudulent land revenue document
Just a
of
minute. It was not for
1992.
claiming your
When he
right.
is a settler, how can he pay the land revenue?
Mr. Chaudhary, this space which was given to you was only a time gap so that you make arrangements. It was not meant to
Yes, madam.
vindicate your claim.
Yes, madam.
That is the difficulty, Mr. Chaudhary. So we clarify this.
Only thing.
We will not record any undertaking by Mr.
Yes,
Chaudhary.
madam.
He is safe and protected, Lord.
Of course.
We
madam.
We are concerned about his protection.
We will not do that. Take it.
Alter, he want to submit something.
Please.
So, Boro company. Yeah.
We are not tinkering with the order. We are only making a clarification. Which clarification also we will say it is not required. We will say that.
Yes, Your Lordship.
But now since the application has been filed, we have to dispose it of.
My only respectful submission, Your Lordship, is that we have to be provided some alternative accommodation, Your Lordship. We do not have any other alternative accommodation. That is our only.
Provided you satisfy that land policy, can we tweak the land policy? They are saying, no.
Any
it
other
is-
place, Your Lordship. That is what the Olga Telly said.
Yeah, the state, this is
Sir.
in the domain of the state. Can we direct the state? We can only ask them that please be as considerate as you can. Can we ask them to settle all of you? Do we
No,
have
no.
that authority?
This will open a floodgate for
No,
all
no.
other evictees of the state.
Possibly, yeah. We will not say that. We cannot say that. I mean, there is a limit to which we can stretch our powers.
Mr. Deori, your whole argument was that let them consider. So therefore, based on your argument, we have
And it was
passed
not,
those and
to
they
be,
continue.
to be fair and frank,
Hmm.
the purpose was to give you a breathing
Breathing
space
space.
to come out,
True, Your Lordship.
nothing beyond. Normally, we would have said that don't evict them. There has to be some justification. Why not evict them? If your possession of the land there was not justified, you should be evicted that very moment. But it was only, I
It
mean,
was also conditional because that was for at that point it was not.
My limited fear, Your
Right.
Lordship, is only if the state can do some rehabilitation, Your Lordship, alternative accommodation.
state can, you can approach the state. We'll say that in case so required, you can approach the state for any benevolent action or something. We can't pass any order. Otherwise, again, this clarification and all that and a
It's
host of.
reflected in the judgment, Your Lordship, the Olga Tillis and.
No, that you realize, Mr. Deori, what are you arguing in the review petition? Everything has been recorded.
Everything has been recorded. We have this. A review petition has been filed. The state against the judgment dated so and so, passed by this court in a slew of writ appeals, the lead appeal being so and so, whereby this court had upheld the validity of the eviction of the respondents herein, but directed the state authorities, especially the Principal Secretary to the Government of Assam, Revenue and Disaster Management Department, and the Deputy Commissioner Kamrup M. Assess the claims of the respondents for their rehabilitation. In terms of the Assam Land Policy 2019 and settlement rules framed under the Regulation 1886. It was further clarified by this court that such assessment would involve verification of landlessness, indigenous status, socioeconomic vulnerability, and absence of alternative accommodation. Keeping that in mind, this court had by the judgment sought to be revised. What did I say? Keeping that in mind, this court had, by the judgment sought to be revised, directed that the exercise of assessing the claims of the respondents for their rehabilitation be completed within a period of 90 days, to be counted from the date of the delivery of the judgment. That in the meanwhile, they ought not to be evicted. The learned advocate general has informed this court that the exercise was completed within the stipulated time, and the claim of the respondents have been rejected by speaking order, which have been annexed with the aforenoted review petition. We were in the first instance surprised as to the reason for filing the present review petition when the directions of this court have already been complied with and a speaking order has been passed. It was the learned advocate general informed this court that paragraph 68 judgment could be misinterpreted, could be prone to misinterpretation in the future. Full stop. For the sake of clarity and at the same time avoiding prolixity, we intend to, it would be appropriate that paragraph 68 of the judgment sought to be revised is extracted here in below. Then you quote paragraph 68. Full stop. Next paragraph. While disposing of the appeals preferred by the respondents, this court had noted that the construction of the hospital had been completed. Land occupied by the appellants is required for future expansion and for ancillary activities. Notwithstanding the urgent need for the land to be vacated, which was originally reserved for hospital, a breathing space was given by this court to meet the ends of justice. Keeping that in mind, it was directed that unless such an exercise is carried out, of considering the cases of the respondents for their settlement, they ought not to be evicted. Evicted. Full stop. The time limit for concluding such exercise was also fixed at 90 days. The embargo on eviction of respondents by virtue of the aforenoted judgment gets triggered only if such exercise were not concluded. There could be dissatisfaction with the speaking orders of the respondents, which could be questioned, which could be questioned by them. But so far as eviction is concerned, this court had ratified the decision to evict the respondents, which judgment has not been questioned. In that view of the matter, we find that no review is required, no review of the judgment is required, with the aforenoted clarification that after the exercise as contemplated in the judgment is over, it would be open for the state to recover the land for the purposes of construction of administrative buildings or other hospital buildings, which is needed urgently. However, it would be open for the state to reconsider the claim of the respondents in case such a request comes, but only subject to the respondents immediately vacating the land on which they have settled themselves. The petition and as per the land policy.
May I pray for 10 days time, Your Lordship, at least for filing our petition before the government, Your Lordship?
I think we have said that, but you vacate first.
Time limit may kindly be fixed, Your Lordship. 10 days
no,
time.
not that
at
time.
least. No,
You
no,
can do it.
no, the Lordship.
No,
We are
no, you vacate.
extremely urgent.
You
Another
vacate.
hospital is being shifted here.
We can't go beyond this.
Already more than 6 months has elapsed.
You are good on, you are good there.
I'm grateful, Your Lordship. I'm very grateful.
So we have not reviewed, we have only clarified.
Lordship. Highly obliged, Lordship.
Daily list for orders, item 1.
We have heard, ऊपर में लिख दो ना, we have heard the land council for the party, सबके appearance slip. Take appearance slips of all.
May it please, madam.
Validation of service को तो हम लोग judgment, this is a review.
Yes, ma'am.
On what ground?
My lord, limited grounds, my lord, regarding the medical opinion, my lord, which I had raised.
Judgment
previously
letter,
also.
yeah. हम लिख रहे
My
हैं.
lord, the,
Just a minute.
yes, ma'am.
Yes. I'm to deal. Only to deal.
Judgment we have not. Yes, limit, what is your limited ground, sir?
My lord, may kindly have page 68 of the appeal, my lord.
Give us the paragraph or internal page number of the judgment.
My lord,
Internal page of the.
Internal page of the judgment.
my lord, my lord. Judgment starts at 157, my lord.
The internal page is on the right hand side.
Page number. Page number of judgment.
Which page? Second page of the order.
I may not be referring to the judgment from the last of the brief. In our brief, the judgment is in the first. Therefore, we are asking
Any
you,
page.
forget about, without any pagination.
Yes, ma'am.
You tell us the internal
Page-
page,
Page 3, my lord.
page 3.
Sorry, ma'am. I'm sorry.
You'll get this experience if you remain at the bar continuously. You'll get this experience. No need to feel sorry. When we say internal page, you have to refer to this. Correct. Yes. There is no paragraphing here, so you can tell us. You
My
can
lord-
count mentally and tell us.
My lord, here, my lord, it is stated, my lord. In support of his contention, Mr. Sikdar has pointed out that a very reputed hospital by the name of Nimhans
Hmm.
has opined that though the appellant had been suffering from grief disorder, but he was fit to resume his duties.
Hmm.
Similar opinion has been rendered by the Board of Directors of Gauhati Medical College and Hospital.
Hmm.
Mr. Sikdar has also pointed out that in similar circumstances, the Supreme Court has directed for reconsideration by the employers where employee has shown any improvement and if not, some alternative arrangement be made, referring to Ravindra Kumar Dhariwal versus Union of India. The learned single judge finding that such depressive behavior is persistent and the appellant still remains under heavy medication, found that it would have been inappropriate to differ with the opinion of the authorities / employer, especially when it concerns service in paramilitary forces, where an employee constable has to display a total alterity of mind and physical agility. In fact, from a perusal of the records and manner in which the appellant was subjected to medical treatment,
Correct.
while-
Correct. Now we have followed. Now, what is it that we have not considered?
my lords, I had observed in this judgment, my lord. My lord may kindly have, my lord, page, my lord, internal page 2, my lord, of the judgment, my lord. Okay. May I?
Yes.
The appellant was recruited as a constable in CRPF and while undergoing the basic training at the Regional Training Center Latur in the year 2014, he remained absent because of sickness. Later, it transpired that he was suffering from lumbar disc disease with nerve compression. All efforts were made by the respondent authorities to have him treated at the hospitals run by the authorities of the training center. After returning from medical leave, the appellant was found to reflect depressive behavior. He was again referred to psychiatric ward of the training hospital, but situation didn't improve. He was diagnosed of major depressive disorder, was put under severe medication. Later, with the evaluation of the appellant by an expert at the hospital, he was declared to be unfit for training and service as a combatant in the armed forces. He was placed in shape 5P and was recommended for invalidation of his service. My lord, my humble submission is, my lord, the fitness certificate that was given to the person, my lord, in the training center, my lord. If my lords kindly have page 68, my lord, the medical opinion rendered by the authorities of the respondent authorities, my lord, page 68, my lord. In the running page 68, my lord. That, my lord, it was given on, my lord, 19/3/2015, my lord.
Invalidation.
19/3/2015. Thereafter, my lord, only after a span of, my lord, 1.5 months, my lord, at page number 70, my lord, 70, my lord would kindly have. Here, my lord, this was given by the Nimhans, my lord. Here, my lord, they have made a categorical remark.
But
Yes,
has it not been considered by the judgment? Now, if you are aggrieved by the judgment, there is a forum, you can challenge it in Supreme Court. But review doesn't mean rehearing of the matter.
Yes.
We have mentioned everything and therefore we made you read also, you read it. We have said that this was argued, this was argued. Now, since you were found to be in shape 5, which is good for invalidation, therefore they invalidated your service. The difficulty is that this is a service where you have to be put in a combatant's role. And if you're suffering from major depression, we cannot ask your employer to keep you under employment. Other benefits you are getting, whether you are getting or not getting, that was not the issue before us. So all these aspects have been dealt by us. That is no ground for that it was decided against you is no ground for filing a review petition or for us to entertain this review petition. There is a limited jurisdiction under review. Correct. So these facts, even if these facts were not stated in the order, it would not have made a case for review. But we have, fortunately, we have referred to these arguments. But finding that the medical board of the organization, of your employer, found you not fit enough to be kept in service, therefore they invalidated it. We also tested it from the point of malefides or some anger against you for some reason or the other. We found none, because when you went under some kind of mental disorder, you were sent to hospital and such facilities were given to you multiple times, not once. They did not want to throw you out of service. They wanted to help you out as much as possible on the government expense, on the employer's expense. That we found. And then we chose not to interfere with the order of invalidation. Now, where is the question of reviewing that order?
My lord, one aspect, my lord, the Ravindra Dhariwal judgment was also referred.
Have we not said that?
Yes, my lord.
That depends upon the authorities. Now, at best, we can say that it could be considered. And see, we must not have said that for the reason that you were invalidated when?
My lord, I was invalidated, my lord, in my lord, 8/8/2015, my lord.
So 11 years later, we would not ask them to even give you a place somewhere. I mean, if there is a provision on a non-combatant role, we couldn't have done that. In fact, if you had to ask for it, you had to pray for it before the authorities. Is it against the cat?
No, my lord, there was my lord, this is against
Single judge.
single judge.
So you should have referred to it in that instance. Now, after 15 years, when this was decided when? 27th of February 2026. Now, that was the reason. Otherwise, normally we give that alternative, accommodation. We chose not to. It was not missing out on that aspect by us. We chose not to for the reason that 15 years have passed by. Now, that also is not possible. And you must have been employed in the meanwhile.
No, my lord, I am.
If you have not been employed, then perhaps your earnability, your mental alacrity is not such that you can be asked to join. I'm sure you would not have waited for the litigation to end. But you have every option to challenge this. No case of review has been made out. Order 47. He's a young counsel. You're a young counsel, therefore we are trying to make you understand. You'll see there are certain parameters on which a review petition is entertained. Correct. So review is not rehearing of the matter. We don't find any reason for us to review. And we don't even want to do this. That perhaps you wanted us to explore the possibility. Are you understanding what the court is talking? ये explore कर सकते थे possibility कि आप कहीं सेटल हो जाते नॉन कम्बैटेंट रोल पे. बट वी डेलिबरेटली चोज नॉट टू डू दैट फॉर द रीजन ऑफ पैसेज ऑफ टाइम. तो ये अब लिखवाने से गड़बड़ है. अब इसको आप चैलेंज करेंगे ऊपर तो ऊपर हो सकता है हो जाए. हम तो ये लिखेंगे ना कि 15 साल हो गए तो अब इनको कहीं रखना वैसे पॉसिबल नहीं है. प्लस यू हैव नॉट प्लीडेड nowhere, neither before the learned single judge nor in appeal, that all this while you have been waiting for the result of the litigation and that you have remained, you have only cared for your health and you have not taken employment elsewhere. तो अब मैं क्यों उनको, why should I saddle your employer with this? That's the whole reason. If you want us to say that, we can say that, but I don't think. Let us give you one forum more to test it, test your luck. We'll say that no good ground has been made out in review. We are dismissing this. We can't help it. We have devoted more time than what this case deserves. Now, any more indulgence you require, I don't think we would be in a position to. My kitty is over. We have heard so and so. Kya naam hai inka? You are Mr. P.R. Sharma.
Yes, my lord.
We have heard Mr. P.R. Sharma, learned advocate for the petitioner. And Mr. B. Decker, the learned central government counsel. The petitioner has questioned the judgment dated 27/2/2026 passed by this court on the ground that this court did not take into account that a private hospital, though of course of repute, had opined that the petitioner, though had been suffering from grief disorder, but was fit to resume his duties. Stop. The judgment is further sought to be revised on the ground that this court ought to have considered the precedent in Ravinder Kumar Dhariwal and another versus Union of India and others, a judgment of the Supreme Court passed in civil appeal number 6924 of 2021, wherein it had been held that if in case of illness, an employee shows an improvement, it would be better if the employer explores the possibility of an alternative arrangement for him. Stop. Both the arguments were taken into account while hearing the appeal and found that in view of the serious mental disorder, in view of serious grief disorder of the appellant, of the petitioner, the employer chose to invalidate his service by keeping his health situation under shape 5. Stop. This court did not explore the possibility of any alternative accommodation for the petitioner in any non-combatant position, only for the reason of passage of time, since his services were invalidated. To stop. Even otherwise, no good ground has been made out for reviewing the judgment dated 27/2/2026. To stop. What the petitioner intends is a rehearing and reappreciation of the facts of the case, which is not possible under the review jurisdiction. Considering this aspect of the matter, we find no merit in this petition. First, the review petition is dismissed.
Item 2.
Mr. Bhuya should withdraw this. Mr. Bhuya, we have devoted 15 pages on an earlier order. Now we want you to take a simple call, withdraw this petition.
My lord, I have prepared some grounds for.
You have prepared grounds also.
Arguing for my lord.
All right, you argue.
My lord, if my lords have allowed me.
Not.
My lord.
Why not? Why not?
No,
But
otherwise I am feeling a
but-
May.
Huh?
Otherwise I am feeling a Mayday, my lord. Going.
You are feeling?
Mayday, my lord. My lord.
क्या दे?
My lord, the ground which has arising out of my lord.
अच्छा.
My lord.
Mayday. अच्छा, I didn't hear it.
Oh, my lord. My lord.
I forgot that today is not first of
No, my lord, we are
Okay, okay.
My lord.
We have recorded every
My
argument
lord,
of yours on,
government had been. yes.
just a minute, on 4/9/2025.
My lord, because.
And we
Lord,
said, just a minute, while we were about to conclude this case,
my lord,
Mr. Bhuyan sought another time to canvass the
Fine.
points again. Considering the fact that the case relates to the appointment process of the year 2000,
my lord.
we were initially reluctant to accede to the request, but on his insistence, we adjourned the matter with the caveat that on the next date, no further adjournment shall be granted to the appellant.
Fine.
But we have granted
Yes, yes.
5 adjournments.
I am deeply obliged for that, my lord.
Yes.
My lord, the ground which we have taken, my lord, in the writ appeal, my lord, is admittedly, my lord, there is a delay, my lord, because this is a selection process
No delay.
initiated in the year 2000, my lord. Our name had also been reflected in the select list also, my lord. That has not been disputed by the respondents also, my lord. Only the ground in the speaking order, my lord, which they have averred, is that, my lord, in spite of our names were included in the select list, we did not approach and, my lord, asking for the appointment and joining. That's why, my lord, we could not be given the appointment, my lord. That is the ground they have taken in the speaking order. If my lordship allows me to just for a moment, my lord, to draw my lordship's attention to the speaking order is at page 420, my lord.
Yes.
My lord, is
Yes.
at page 420, my lord. May I read, my lord?
Yes.
My lord, I will.
Just a minute.
My lord.
Yes. Yes.
My lord.
420.
420, my lord.
Not a good number.
My lord, that's why I pronounced 420.
But now it is no longer
No longer.
same section.
My
Yes.
lord, whereas the petitioners have claimed that 406 numbers of candidates have been left out of selection in the post of constable when the Assam Police held in pursuant to the advertisement dated 17/1/2000. The recruitment rallies were held either in the different districts or in the battalion headquarters in the month of February 2000. Altogether, 2831 candidates, including the candidates of so-and-so, as per the provisions, were selected. Several writ petition challenges the recruitment process were filed in WPC number wide order dated the Honorable Gauhati High Court directed the Director General of Police Assam to consider the case in accordance with the policy of the state government in WPC number so-and-so. Wide order dated 2/5/2003, the Honorable Gauhati High Court directed the respondents to follow the procedure prescribed by law and process must be transparent and non-arbitrary. In WPC number 3035 of 2003, the Gauhati High Court directed that no person should be appointed as constable in Assam Police without the process of law, and all the High Court directions were followed. Whereas all Assam MOBC Sonmilani Gauhati filed WPC number on behalf of 361 candidates challenging the advertisement dated so-and-so. The Honorable Gauhati High Court wide order dated suspended the advertisement dated, hence filling up of vacancies of constable in terms of the advertisement dated could not be given effect. Whereas the Honorable Gauhati High Court wide order dated 22/1/2004 in WPC number and 94 and 94 other connected writ petitions appointed a committee to inquire into the matter of recruitment of the police constable in Assam Police. The Honorable Court was pleased to appoint Sri so-and-so retired Chief Secretary to the Government of Assam and Sri so-and-so IS and directing the Sri so-and-so IPS to be responsible for assisting the committee by making available all such resources and records, etc., as may be required by the committees to complete its assigned task. 3D so-and-so IS had to be central deputation, and the Honorable Court appointed a person whom the Chief Secretary may consider to be fit for inclusion in the said committee. Later, Sri so-and-so IS was appointed as the member in place of Sri so-and-so of the High Court directed the committee to submit its report on so-and-so. The committee report was submitted on so-and-so date. The recruitment reports sent by the ranch DIGs were destroyed as per provision of Rule 144 numbers Part 2 of the Assam Police Manual. It was mentioned in the fact finding report also. Now, my lord, from page 6, our case, clause 6, my lord, whereas there was 283 numbers of candidates in the central select list, they were appointed except 423 candidates, out of whom 406 candidates did not report for appointment, while total number of 17 candidates were rejected owing to their deficiencies in the physical eligibility. Whereas the Honorable Gauhati High Court, wide order dated so and so, other writ petitions, the recruitment of the constable was conducted in 2004 and in subsequent years also, in which the vacancies of constables were filled up. The Gauhati High Court, wide order dated in WPC number so and so, similarly situated writ petition dismissed with a direction that the matter should be allowed to rest at said and ought not to be carried any further. After the High Court order dated in WPC number so and so and 147 similarly situated writ petition, the operation of the recruitment pursuant to the advertisement was no longer existing and those vacant posts of constables were filled up in subsequent recruitments. Whereas the Rule 21 of the Assam Police Manual Part 3, a strong and healthy young man between the age of 18 and 25 should be chosen as a result. The recruitment was in pursuant to the advertisement dated 17/1/2000. Those candidates are now likely to be more than 45 years. In view of the aforesaid rule, the candidates of the year pursuant to the advertisement dated 17/1/2000 are not permissible as per the Assam Police Manual Part 3. Moreover, there is no vacancy of 406 candidate 2 as prayed for as the Gauhati High Court, wide order dated in so and so similarly situated writ petition, issued an order that the matter should be allowed to set at rest and ought not to be carried any further. The representation dated is considered and disposed.
Mr. Bhuya, you
My
are
lord.
reading the whole thing. We have read it 5 times over.
My lord, my lord. No, my lord, my respectful submission before my lord is that, my lord, what is there on record, my lord, I cannot deny, my lord. Even my writ appeal is dismissed, my lord. But the only thing is that, my lord, it is an admitted fact, my lord, that our names were included in the select list and, my lord, we are pursuing. We are
Where
not
is
sleeping.
the, so
My lord,
this is a statement made by you.
my lord,
This is a sporadic statement, a casual statement made by a police officer,
my lord.
and there are no records.
That is,
All
my
got
lord.
burned.
That is,
And it is a case of 2000.
that is
Now,
correct.
can that be reconstructed now?
No,
All of you are beyond 45 years. This is police constable appointment. Can anything be done? How
But,
many
my
writ
lord,
petitions have been filed by you?
my lord, with my very
5 to 6 writ petitions were filed, and in the last
My lord.
occasion, the single judge said that it is better to give it a decent, of course, in a different language,
My lord.
but the single judge says that let us give it a decent burial.
burial.
But somehow the other, the corpse was taken out, like kya kehte hain, exhumation. It was exhumed, and
Right.
we have also fallen prey to your
No, my lord,
your great efforts.
my lord, I have a-
कुछ नहीं है इसमें.
my lord, I have a very limited, my lord, knowledge in, my lord, regarding
Compensation.
this, my lord. But my lord, the issue is that, my lord, when a person's name is already there in a merit list, my lord, the manner in which the
You
arbitrary
cannot say, where from we will read this merit list?
merit list, from their speaking order, my lord,
What
they have
we
not
don't-
denied,
Anyway, ठीक.
my lord, they have not denied, my lord. So that we do not reflect in the merit list. Now, my lord, in the arbitrary manner, the manner in which they have rejected, there is no valid ground for them, my lord, for their, the appointment order which were not issued to us, my lord. So therefore, my lord, the delay ground and the age ground which they have taken, my lord, had we been appointed, my lord, in the year 2000, then, my lord, obviously we could have young and healthy and more fit. Now, my lord, at this moment, my lord, admittedly, we are 40 plus, my lord, 38, 45 along with like this, my lord. So therefore, my lord, the age cannot be a ground to deny our appointment because it is your fault. It is the fault of the state, my lord, they have not appointed us. And for their fault, my lord, we are now suffering, my lord. That is another, my lord, many judgments in this case, my lord, Honorable Apex Court has held, my lord, a small, my lord, investment I have given to the issue, my lord, whether I can satisfy with those judgments, my lord. So, my lord, today I have.
No,
no.
So, my lord,
This is not fair. Mr. It's not fair.
Mr. Bhuyan,
This-
don't do this. You have a bigger responsibility now with that.
My lord can dispose of.
Uh-huh. Dismissed. You can see 5 times over
No,
we
no,
have
my
it.
lord, I am not seeking any further adjournment, my lord. My lord can dispose of.
All right. Dismissed.
Mild.
Ah, yeah, इनके पास दे दो.
Mild. And sorry for that I was also not about to make my adjournment prayer, my lord. If my lordship allows me, then I could have given the my lord.
No, you keep those judgments
My lord, my lord.
whenever we require it,
My lord.
because we require judgments every day. We will take help from it. But in this case, I
No,
don't think any
I'm
judgment
not
can help.
making any adjournment.
Keep that hot
All right.
right. It's all right, Mr.
Well.
Bhuyan, we have heard you. You have,
Well.
and you know, lawyers. See, these constables, these aspirants for the post of constable,
My lord.
their quality decreases with the passage of time. Advocates, no, they're a different class. With passage of time, they become more experienced.
Well.
They become more stable. वो तो है ही है. आप keep those judgments. We may ask for it at times.
Oblige.
All.
Item 3 to 11.
Item kita complete.
Who are you?
5, 7, 8, 9. 3, 5,
My lord, I
No,
appear.
no,
in
no,
three-
no. I'm asking the other side. Who are you?
I am the rich petitioner also. I am the also one of bidder also. The tender process also I participated in.
And how do you justify this judgment?
I have not challenged the judgment.
How do you justify that judgment?
The judgment of the.
The challenge has been made by
Yes.
him. We don't find it to be tenable at all.
No, lordship, the learned, the single judge has rightly held that lordship is the order that was.
Tell me one thing, Mr. Chaudhary.
Yes, my lord.
That time 70%, since it's a state, so everything has been stayed.
My lord, I am prepared to complete the work.
No, till now you have not completed.
No,
Why?
no, some portion are left out. About 70-80% we completed. Balance we are prepared to complete, carry out.
Come here, Mr. Nath.
We have.
You are not to be faulted in this occasion. Come this side. It's the court. Come that side, no?
We are for the. State has also prepared evidence.
Oh, you have also preferred it.
That's why he's on this side.
We have.
Oh, sorry. I thought you were responding.
Hello, we have prepared 4 appeals, Lord. Item number 4, 6, 10, and 11 is our appeal. And Lord, in fact, at that point of time, 70 to 80% work were done.
Yes.
Lord, these are.
But why did you stop work? Since the order was stayed.
We have instructed the contractor, the appellants here, represented by my.
You should have continued and finished the work. It would have become infructuous.
We have.
The order was not acted
No,
upon.
my lord, there was some.
Sorry, Honorable Board,
My lord, now I understand we have been extended the period, we'll complete it.
If you extend it completely.
And even otherwise, my lord, there was no procedural impropriety in the decision making process.
Absolutely. We should.
And that resolution is there. And it's a standard prescription and a
entire-
practice, my lord.
the
Whenever the
entire-
rates are low, we should take performance guarantee. That was taken.
No, Mr. Chaudhary, the entire law was reiterated in the judgment, but application was different. We are not supposed to interfere in this manner. Fortunately, it was stayed by the division bench long time back.
Yes.
You should have, what we are telling you is that you should have completed the work in the meanwhile. The state should have asked you to complete it.
That, my lord.
In fact, on
Historical
two occasions, my lord, we have written letters to them to complete the
Well,
work.
the time, I understand we have been extended time up to 30th June, we'll complete it.
30th of June.
Oh.
Chaliye.
Lordship, may I submit?
Yeah, no. Before concluding, we'll hear you.
Yes. So the thing is that, Lordship, the first, when requisition was brought in this filed, this honorable court stayed the matter, not proceed further. Despite getting stay order, Lordship, the state respondent, Lordship, has released, they have stated that they have released 70% of the award. But as per my instruction from my client, still they have not paid a single penny, Lordship, because that is why I am saying, Lordship, that
They have not paid a single penny.
yes, Lordship.
But
They
to
have
whom?
just verbally, they have just,
Who has not paid penny?
Lordship, the state authorities.
To
They have
whom?
to the Lordship, the
Contractor.
Yes.
So the complaint should be made from him or?
Why I am submitting, Lordship? Why I am submitting, Lordship? Because they have, the state has filed an affidavit stating that 70% has been released. How a officer can also file such a statement, a false statement, Lordship, that they have released 70%, whereas they have not released any person, Lordship. That is a serious allegation, Lordship. I'm as a Lordship, for petitioners, I am stating. Also, Lordship, that I have got some allegation. I have found out some documents, Lordship, which are false. They have also, the single judge has also, Lordship, felt that these documents are false document. So despite my lordship finding out those documents or pointing out those documents first, the state is supporting those forgeries. State is supporting those persons. This is a document.
Now we are on a different aspect altogether. You are Mr. Kalita.
Lordship,
Mr. Kalita, you remember Jagdish Mandal?
lordship.
Huh? Jagdish Mandal versus State of West Bengal.
Yes.
State of West Bengal versus Jagdish Mandal. It says that the court should keep its hand away. That these are matters which are to be decided by the state unless there are certain conditions fixed. That judgment still holds true. That holds the field. Number one. Number two, whose tin, what is that called? Gift tin. What is that term used? The tin which was, I mean, those things were decided. He had quoted a rate, Mr. Chaudhary had quoted a rate which was below 15%
Yes.
of the minimum. Correct.
Lordship.
So therefore, it triggered another response from the authorities.
Yeah.
It had to be verified by committee.
Yes.
The committee verified,
Lordship.
gave a certification. Now, where did the court come in between to question that this was bad, especially when it was stated that 70% of the work was done, whether payment made, not made? We are on the very propriety of the court going into this matter at that stage.
Lordship. But
How do you think this statement would attract any controversy or anything?
whatever statement lordship stated made, all are false statement lordship. The work order was released lordship on March. They have stated that 70% has been done within 10 days. Is it possible lordship on the part of a employer? 70% has been completed within 10 days. False statement has been given by state only to lordship to give the work order to the other side lordship. That is the first thing. Second thing is that lordship, what lordship is saying that below 50%, not below beyond 15%. If someone's quoted beyond 50% of rate, then they have to submit a justification report stating that.
That justification
Yes,
was
the
given.
justification report. In the justification report, the tender notice also says that they have to lordship
See,
specify.
it is our habit to give complete space to the lawyers who have come prepared. You have come prepared, we are hearing you.
Lordship, I'm not prepared, lordship. I thought
We are
lordship,
hearing
that
you. We don't want to
Lordship,
cut short
but
your
I fixed for
arguments.
hearing lordship.
We
until the-
don't want to cut short the arguments, especially of younger advocates, which you would have noticed. We hear, but then we are not appreciating that
No,
argument.
lordship may fix for
We are
hearing.
hearing, we are not appreciating.
They're hearing it today.
No, this is matter comes for orders only. So if lordship.
It has come for orders.
No, admission notice.
Admission.
Then lordship, I am ready to have lordship.
Yes, sir.
So the first thing is that lordship, as per clause Z, the tender process lordship, it is stated that the person who will tender that is beyond 15% of it, they have to give a justification report along with lordship photo materials to be available and a photocopy of that. They have given a document lordship stating that they will supply the articles from my enterprise. The my enterprise document, while I verified in the lordship GST portal, I found that the GST number mentioned in the my enterprise is not of that particular enterprise. This GST number belongs to some others. Meaning thereby lordship, in 5 writ petition, I have preferred 5 writ petition. In all 5 writ petition, they have given same documents. All the justification report and the
Correct.
the supply-
Correct. The single judge has expressed his surprise
Yes.
that there is nothing unusual about it. 5 persons of the same family.
Same,
Same family because this observation was because of the address given by all the 5 persons, but they were different persons.
and all
Is it?
documents are same.
But why should court enter into this?
So
That's our question.
It is not lordship. Apparently, when the documents are false, I believe lordship, it is.
The collusion gets reflected if a higher rate is accepted.
Yes.
Here a lower rate has been accepted. They
No,
will not.
lordship,
They will not be collusive. to
Only
get-
the lower rate is what lordship is appreciating. The only the lower price they have quoted is only to get the work order. In fact, lordship, they have.
But
done
they
the
can't.
thing.
They can't raise bills beyond that, no?
That is different. I'm not pressing on that. What they are also quoting beyond 15%, then they must have to justify their
Correct.
condition.
Now just formulate your arguments. We are not going to disturb you in between. You formulate one thing that
Yes.
5 different persons, but one name, one person, one family.
One,
Therefore, yes. Next.
Next is that lordship, the my enterprise document, the quotation they have lordship to justify their beyond 50%, they have given quotation of my enterprise. So my enterprise lordship, they have given a GST number. While I verified the GST number in GST portal, I found that this number belongs to some other person. not this Ma Enterprise. After Lordship filing this case, the Ma Enterprise, they have submitted the documents stating that Lordship at page 111, Ma Enterprise has given a clarification that with reference to the subject cited above, it is to inform you that inadvertently the GST number has been put by the computer person without my knowledge in the quotation dated so. In fact, I do not have any GST number. So these documents was also Lordship annexed by the respondent where is Lordship no seal, no sign of Ma Enterprise. So all documents, therefore, if Lordship is allowing the petition, I have nothing to say. I will sign my argument also. But Lordship, what I am respectfully submitting is that the fraudulent action should not be Lordship indulged by the state authorities. Lordship. Despite all these fraudulent documents submitted, I have brought to their knowledge, still state are supporting that person. State has preferred this affair. But I believe Lordship state should have stopped their works after getting all those documents. But state itself are supporting those persons who are fraudulently, they are trying to siphon the public money. Nothing more, Lordship. In fact, Lordship, practically they have done nothing. 70%, if Lordship till today Lordship verified their work code, Lordship will find more than 40 to 35% has been done, not 75%. And 75% has to be assessed by the Lordship, the executive engineer or junior engineer Lordship on the basis of what portion they have done, whether only the structure has been done, whether electrification has been done, whether water collection, all things has to be assessed. Then only the question of percentage, the work they have done is come to in the picture. But they have done nothing. Only they have that is some pillars and construction some wall. And that has been shown as 70%. So at least Lordship, the private aspect I am not saying about that, but state should Lordship rested, should interfere all this Lordship for the work. That is my humble submission. And how Lordship, despite there is a stay order, how can state release the fund? That is also another issue Lordship. If Lordship, if this kind of Lordship work is allowed to the state respondent, then Lordship, the purpose of court order has been nothing.
We are on a different issue, Mr.
No,
Kalita.
Lordship, still I am still issue survive. That is why I am praying before the Lordship. Despite there is a stay order, how state can release the fund without Lordship leave of this
Day of the judgment,
No, Lordship. In the first writ petition.
in the meantime, effect.
First writ petition, Lordship. While the first writ petition was filed, there was a stay order. While the writ petition was pending, Lordship, they have released the amount.
Correct,
How they
correct.
can do?
Who is, you are Diganta Bora?
Yes.
You have appeared.
Yes.
And then Bobita Bora is who?
Is another appellant, my lord.
Another appellant. And then
Hemanta Bora,
Diganta Bora again.
then my
Hemanta
lord
Kumar
Hemanta
Bora.
Kumar Bora.
So these are three appellants.
Hemanta Kumar Bora, Diganta Bora, Bobita Bora.
Already common judgment. Huh? Yes, okay. And the state appeal is this W 381.
Item number 4,
381, 4, 6 and
10 and 11.
11. हमारे पास दे दो the all the appeals stand allowed. All appeals are लिखा ही देते हैं हम. Let me dictate it now or write.
Deep level.
All- Mr. Chaudhary, you can go. Somebody will be here.
Yes, yes, yes.
We will be dictating
My
the
junior
order
will be there.
just now. Anybody will be here. Some factual errors,
Yes.
it should be pointed out. Mr. Nath, he is also appellate.
I'm
All right.
I'm here.
अंदर लिख रहे हैं अंदर लिख अब कोई टेंशन नहीं है ठीक है appeals have been heard together and are being disposed of by this common judgment. Next, we have heard so-and-so for the we have heard Mr. Kane Chaudhary, learned senior advocate for appellants in so-and-so, Mr. D. Nath, senior government advocate Assam in appeal number so-and-so, and Mr. Kalita for the respondents in all the appeals. by the impugned common judgment single judge of this court has opined that the process adopted for allotting the work to appellants WA number so and so was not in accordance with law. Further directed that the work orders dated 6/1/2024 be not acted upon henceforth. However, it was clarified that since progress was made, since work was carried out against such work order, the balance work should be given to another eligible bidder who would qualify for the work pursuant to the tender process. In one of the writ petitions before the court, since there was no progress against the work order, it was directed that the work be allotted to the eligible bidder in the same tender process. The aforenoted judgment was passed in 5 of the writ petitions. 5 of the writ petitions. This case involves a public tender issued by Animal Husbandry and Veterinary Department. Construction of works under RIDF 27 in Roman, XX and Roman 7. The work related to construction of Assam type sub-center building with electrification, water supply and sanitary works, etc. in the district of Nalbari. The estimated cost of the work was 33,71,000 with a completion period of 180 days only. The tender followed a 2-bid system, technical and financial. The appellants, so in appeal number so and so, Jam Bora, Diganta Bora, Bhakta Bora, Diganta Bora, Hemanta Kumar Bora, the appellants in appeal number so and so, registered contractors stated emerged as the lowest bidder. The rates offered by them was more than 15% below the current Delhi state rates. DSR is Delhi state rates. I don't think so.
Detailed schedule rate.
Detailed schedule rate.
Schedule rate.
15% below the current detailed schedule rates. Bracket DSR. Next. Clause 2A bracket small g of the bid document specified that any bidder who quotes beyond 15% below DSR must submit detailed justification, analysis, photographic evidence of its infrastructure and the ongoing projects. such bids could be rejected by the bid process management committee. Justification for quoting such a low rate was found incorrect, or that the claim of such bidder was not claim of such bidder is not found to be correct on physical verification. According to the appellants, they had submitted the required documents for the evaluation of their bids. After preliminary technical evaluation, the bid process management committee had directed a physical verification by an engineer of the department who had submitted a report confirming the correctness of the claims of the appellants. Based on such report, the bid process management committee recommended awarding the work to the appellants who were adjudged L1, but subject to depositing an additional performance guarantee of 12% and an undertaking that the work shall be completed within time. Pursuant to this, it has been pursuant to this, the formal work orders issued on 6/1/2024. The claim of the appellants as on date, next paragraph, the claim of the appellants as on date is that more than 70% of the work has been completed. One Balen Rai Medi, who is the respondent in these set of appeals, unsuccessful bidder, the work order by filing petition before this court. So the contentions raised by him before the learned single judge was that there were no proper justification, quotation of such low rates. It was found to be in order because of the collusion of the state. The physical verification process which was undertaken was not in accordance with the settled procedure. It was also alleged that no proper scrutiny was made. This, there were various other objections raised by Mr. Medi with respect to the validity of the supporting documents by the appellants, especially quotation from Ma Enterprise, the GSTIN codes, and identical photographs used for multiple sites. for physical verification. The learned single judge sustained those objections that it was incorrect to accept a quotation from one of the appellants with a GSTIN which did not belong to it. It was further held by the learned single judge that the clarificatory letter from my enterprises was also not worth accepting, as it was on a plain piece of paper and not on any letterhead. There was no seal of the firm either on such clarificatory letter. The learned single judge relied on the statement on the evidence produced by Mr. Mary / the respondent, that the photographs submitted as evidence by the engineer of the department demonstrate that the claim of the appellants was genuine, were identical across multiple unrelated work sites in different locations. Those photographs, the learned single judge held, ought not to have been accepted as an evidentiary proof because there was no geotagging and lacked bona fides. The learned single judge therefore concluded that the entire verification process in case of low rate quoted by the by the appellants appeared to be predetermined and biased in favor of the appellants. There was no scrutiny of the quotation. That way, it was held that the decision making was improper and the department also failed in its higher obligation to verify the documents properly. Verify the documents properly. Mr. Ken Chaudhary, learned senior advocate for appellants in so-and-so, and Mr. D. Nath, learned senior government advocate, Assam, in appeal number so-and-so, have submitted that the judgment impugned is not fit to be sustained in the eyes of law for the manifest error appreciating the law with regard to interference in tender processes. There's that as per clause 2A bracket G, the bidders quoting a bid 15% below the current DSR were obligated to submit a justification of quoting the rates in detail with proper rate analysis along with the evidence with their bids. The appellants, in compliance of the aforenoted requirement, had submitted the justification for quoting a rate below 15% with photo evidence. Stop. A field verification was also conducted. The appellants were recommended as L1 bidder. With such background facts, it has been argued that the learned single judge ought not to have made such an interference at the instance of an unsuccessful bidder whose offer was much higher than the appellant's. It was submitted that the judgment impugned smacks appellate order the decision-making authority against the decision-making of the tender floating authority, especially the committee which evaluated the tenders, which evaluated the bids. And which committee comprised experts in the domain subject. Factually also, the judgment has been questioned on the ground that for a successful bidder, he was required to have his GST registration certificate with up-to-date challan. The appellant was a bidder, not Ma Enterprises, whose possession of a valid GSTIN was not relevant for deciding the issue. It was also argued that the GSTIN of the material supplier was not mandatory. What was essential was the rate of materials offered by him and its availability. though though the learned single judge, right, the impugned judgment has spelled out the correct law on the subject, that in matters of tender, there ought to be least interference unless the decision making tested with malifides unreasonableness, comma, interference has been made at a stage when more than 70% of the work had already been completed. It was very unusual to have raised eyebrows over the appellants coming from the same family. This is not something new in the business world. That account only, comma, the decision making and the issuance of work orders could not have been faulted with. Could not have been faulted with. The advisable restraint in exercise of judicial review in such matters, comma, correctly been argued, has been thrown to the winds. The judgments of the Supreme Court in Afcons Infrastructure Limited versus Nagpur Metro Rail Corporation Limited and another 16 SCC 818 and Bharat Coking Coal Limited versus AMR Dev Prabha and others 2020 16 SCC 759 has been completely disregarded. Stop. Mr. Kalita, representing the respondents, has submitted that the assertion was made by the state that payments have been made for the 70% of the work. Stop. The fallacy in such a statement is evident of it. Stop. In a very short span of time, more than 70% work is claimed to have been completed, which is an incorrect statement. He agrees that the work did progress against the work order, against the respective work orders, but major work was still incomplete. Under such circumstances, there would have had been no justification for the state to release the payments without proper certification in the measurement book by the concerned engineer of the department. Thus, a bold statement has been made before the writ court, as also before this court, regarding payments having been made to the contractor. The appellants have never questioned, the appellants have never questioned such statement, nor do we realize, nor do we understand the importance of such issue, especially when for the lower rates quoted by the appellants in so-and-so, the procedure delineated in the tender document was applied and justifications along with rate analysis and photographic evidence submitted by the appellants were accepted by the bid processing committee.
Telephonically verified, that's what we, they have telephonically verified the justification report. Page 80 Lordship.
By the bid processing committee. Stop. Questioning the verification report as collusive clearly appears to be an overarching allegation of an unsuccessful bidder, which ought not to have been taken into account for interfering with the work orders at a stage when construction process had started. First up, the net result has been that the work process, that the speed of the work was halted. Stop. What we are surprised at is that despite the stay by the appellate court over the operation of the judgment of the learned single judge, the work was not completed in the meanwhile. Stop. Mr. Nath, learned counsel for the state, has submitted that for some reason or the other, perhaps because of the Damocles sword hanging over the head of the appellants in so and so, work could not be completed despite the department giving green signal to the appellants. But in view of the extended time given to the appellants in so and so, the work is likely to be completed by the time limit set in the extension, that is till
30th of June.
of
June
till 30th of June.
2026.
We hold the interference by the learned single judge at that stage on the grounds referred to above with the work order to be unjustified. We therefore set aside the judgment impugned in the present set of appeals and direct that the entire work should be completed as per the specification within the time granted by the department. All the appeals stand dismissed accordingly.
Highly obliged, huh?
And you see workers in settlement. 15, 16. Call it 15, 16.
Item 15 and 16.
Obliged, Lordship.
इसको भर लिया तो देखते हैं अपनी करेक्शन करते हैं, इससे ज्यादा तो लिखने प्राइस करेंगे. Yes. Yes, Mr. Das Gupta.
In this case, basically facts is that an industrial dispute was espoused.
What is it?
An industrial dispute
Hmm.
was raised in the year 2009 for fixation of wages to the contract laborer. Basically, below, it is the case of oil sector. Here, the payment of minimum wages, scheduled employment is not applicable. And for that reason, the industrial dispute was raised.
Now, Mr. Das Gupta, we would like you to tell us the issue before the learned single judge. What was the issue? What was the factual background? And then the judgment. Then we shall apply our mind to the appeal. Just formulate your arguments. We will reassemble at 12:30.
At
12:30, 10 minutes. Give us 10 minutes. Yes.
Not pretty much. Lord, in this case, a settlement was arrived between the ONGC Limited and the contract laborers. And in this settlement, it was agreed that the contractor will change from time to time, but the contract laborer will not be changed. That is the basic essence of the contract settlement. There are other beneficial provisions in this settlement.
Now, look, at that relevant time, when the settlement was arrived, there was an industrial dispute pending before the central government industrial tribunal at Gauhati. And now this reference was decided in terms of this settlement.
Where is the award of 25th of September 2014? Show us the award.
Is. Huh? Ready for it. Huh?
Which 50.
Yes.
Which 50 blood.
Page?
50. In this award, terms of settlement have been incorporated at page 59. And this award is applicable only for the workers who were working on 1/4/2012. The person concerned who were disengaged before that date, prior to that date, they will not be covered by the settlement. That is the problem with us. We have to have
What was the cutoff date fixed?
Millard.
What was the
One,
cutoff
one.
date fixed?
2000.
1/4/2012. Huh?
1/4/2012.
1/4/2000.
The contract officers were engaged as on 2/6 and continue to be engaged till date and also were engaged on.
दो तरह का set है, but the cutoff date was 1/4/2012. The rest others it will not apply or until.
Effective from 1/4.
And what do you want?
Now, look, when this
You
award
want
was-
that those workers who are disengaged by their contractor,
No,
they
see-
should be rehired and they be given the same benefit.
No.
Is that what you want?
No. Some of the workers, they were disengaged prior to 1/4/2012. And unfortunately, they could not bring in the full of the award. Now, we had an occasion to file an application under section 33A before the industrial tribunal. Our contention was that during the pendency of the proceeding, a large number of contract laborers were disengaged. So it amounts to violation of section 33, etc. And so we filed it. But we had to withdraw this application because there is a clause
Well,
in the
let's let bygone things be bygone. Now, your prayer before the single judge was what?
Simply, my prayer is that in the event of engagement of any contract labor, new contract labor, the ex-contract labor's case should be considered.
Could it have been done by the learned single judge? Could it have been done by the learned single judge when the entire settlement is made part of the industrial award? Can it be tinkered with?
No, my learned settlement, learned single judge's view is that you are covered by section 18 of the Industrial Dispute Act. So as you are covered by the Industrial Dispute Act, you have nothing to do with it. We have nothing to do. That is his understanding, Millard. And
That's somehow the other, that's our understanding also, Mr. Dasgupta. Unless you dislodge this opinion from our mind.
No, for that reason, Millard, I would like to invite your lordships to go through the provisions of section 25H of the Industrial Dispute Act.
Industrial disputes.
Because these people were retained.
This is with respect to implementation of a fair wage policy. That will not govern the
No,
principles.
our. case
Anyway,
is
you
that-
argue section
Let us-
25.
contract labor who were disengaged prior to 1/4/2005, the ONGC may require to engage some contract labor in future. When they would engage in contract labor in future, so the previous contract labor's case should be considered. That is the mandate of section 25H.
Admission के लिए कि hearing के लिए?
Admission.
Hearing नहीं hearing में. Hearing.
Where any workmen are retrenched, an employer proposes to take his employee, any person shall in such matter as may be prescribed, give an opportunity to the retrenched workmen who are citizens of India to offer themselves for re-employment, and as such retrenched workmen who offer themselves for re-employment shall have a preference over the other purposes. So here the contract labor, contractor will change from time to time, contract laborers will not be changed. But despite that, if they want to engage some new contract labor,
It's 70.
so extra contract labor should have a preference. That was a limited player.
Hmm. 25 GH here. Re-employment.
This one replacement and the other different down replacement.
There is no difficulty in taking them, but whether the wage policy would be applicable to them, that's the question.
Yes.
As otherwise, if the state government comes up with a scheduled rate, has it come, Mr. Sahiwala?
Look, there are some other provisions in the fair wage policies with regard to the provident fund, with regard to the gratuity. In fact, Lord, if we analyze this fair wage policy settlement, it will appear the contract laborers are the employees of the principal employer.
So, सुनना होगा. Now, what is your response to this? 25H.
As per their settlement, my lord, it is.
Forget about settlement.
Well,
They have
but-
understood.
So they
Whether
cannot-
the High Court's power under 226 was limited.
My lord, because they say that the persons who were not in the job, my lord, on 1/4, they should be engaged.
No,
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 that
no.
is not a
Prior
settlement.
to-
That's not something which is being argued. He says, if I have understood him correctly,
Hello.
he says that give opportunity to the
Yes.
workers who have been disengaged to be rehired, and then that wage policy would be applicable to them.
My lord,
In the event of engagement of contract labor.
employees of the principal, my lord, here, not ONGC.
How does it adversely affect you?
Because
It'll not be a big number, because otherwise also they have to pay.
no,
He
they are contractors, my lord.
is arguing that this contractor will be changed, but not their position. So they say indirectly we are employed under ONGC. That is what he has argued.
Correct, my lord.
So therefore he
Contractor-
says,
that is why-
whosoever the contractor,
Is
if
what-
I am taken back, the policy that awards may be applicable to us only. But I think.
My lord, that was the
This is
settlement made, my lord. That was the settlement made. You can also see, my lord, the settlement, my lord, that is at page 38, my lord.
Then the award itself is certainly quoted.
That is quoted, award,
Page 54.
page 58. That is the award quoted, my lord. That is the, my lord, name. So they cannot go beyond that, my lord.
Just
At page 59, my lord.
कौन पेज पर था कॉन्ट्रैक्ट लेबर that award
Award 59 में terms of settlement.
59
Terms of settlement.
terms of settlement.
Continue. Contract will change. Lesser will continue. Everything happening as a superannuation. Base engagement, retrenchment में आएगा, नहीं आएगा, many things will happen. But it is there.
नहीं of contract का agreement है कि all those who were engaged as on 24/6/2008 and continued to be engaged till date, ठीक है 8 से, and all those who were engaged on 1/1/11 मतलब जो भी हैं और सब चूंकि इतना दो set of workers को engage कर रहा है, for the reason that the cutoff date would be this wage revision would be from 1/4/2012. तो 1/4/2012 से करेगा
Effect आएगा, applicable होगा तो those हैं.
to those events. The rest का, however, the contract labor can be removed on the following grounds. और wage revision है, minimum wage to ensure the management. Accordingly, the wages for each contractor shall be increased. The wages for each contract labor shall be increased with 35% of prevailing minimum wages. Here, wage revision shall be effective. In existing contracts, the contractor will make the payment of additional wages as above and recover the same from MGC, correct? In future contracts, this will form a part of the tender conditions. तो उतना उसमें उसको 2012 से देने के लिए तो नहीं करेंगे अभी है. No, Mr. Dasgupta, we can't help you. That this principle of retrenchment will not come. See, look at this. Look at the terms of the agreement. Don't unnecessarily dilate the issue. Let us see. Now come to the terms of settlement. Page 59.
Yes,
First paragraph.
job security.
Yeah.
Both the parties, they will continue with that.
So this is with respect to persons who have been engaged and who continue. And look at the cutoff date. The
Yes.
contract workers who were engaged as on 24/6/2008 and continued to be engaged till date, and also those, there are two sets, and also those who were engaged on 1/11/2011,
Yes, yes.
because otherwise there would have been a confusion.
Yes, yes.
That persons who were appointed
Yes, yes.
in the year 11
For
may
them-
not get that benefit.
Yes, yes, for them this will be applicable.
Have continued till date will only be eligible to be included in this.
Yes.
Now, this will include, because this wage revision of 35% hike, this would be effective from 1/4/2012.
The person concerned who are working 1/4/2012.
All those.
It
So
will not be
adding
applicable.
more-
The person concerned who were disengaged prior to 1/4/2012. So my.
No, that is not there. You are reading something else into it. Now, question is that those persons who are engaged on 24/6/2008 continues till the award. And those persons who were engaged on 1/1/2011 till the award, they would get the wages, the hike
They
in
would
the
benefit the
wages,
benefits of settlement.
benefits of settlement, and they will get from 1/4/2012.
Yes, that is, I
Pa-
cannot go beyond that.
No
I got-
difficulty. Future contract, the contract labor could be future contract would be governed by this agreement. But why put in this category for them to be paid from 2012?
No,
They have been disengaged,
why
they have been
the
disengaged.
difficulty is that when this dispute was raised before the tribunal, there were 1,500 workers. And when this settlement would have been done, the number of contract labor reduced to 207.
Mr. Das, it must have been for that reason only that they would have agreed for this conciliation. That many have gone, let's see, those who have retained.
No, in the event
No,
of.
no, it will open a floodgate and we can't do
In
that.
the event of, I mean, simply for enforcement of industrial section 12, in the event of engagement of contract labor in future, the provisions of the 25(8) can be considered.
No, no, that was a separate issue, but now in this terms of settlement, we can't introduce that.
No, I am not imposing that.
That's a separate dispute. That is for retrenchment and that's for resettlement. So far as wage
Whenever-
revision is concerned for
Continuation 60 years.
what is it? Arrears payment from 2012. That will not be given to all and sundry.
No,
Anybody.
I am not claiming that. My claim is that.
Who backdoor you're claiming that only, Mr. Das Gupta.
In the event of engagement of contract labor in future, our case should be considered this
So
much. and
that is the
nothing
terms
else.
of the agreement. That is the term of the agreement. Who disputes it? You should not even file this case.
Yes. If you
The terms of agreement has been ratified. Terms of agreement says what? Therefore, we asked you to come to page 59, come to page 60.
Hmm.
Come to page 60.
Yes.
60, last three lines in the first paragraph.
Last three lines.
In the first paragraph, which begins from in
The
existing
above
contract.
wage revision shall be effective from 1st April.
In existing contracts.
In existing contract, the contractors will make the payment of additional wages above same ONGC in future contractor. This will be from
Okay.
In
If you are
future
to
contracts,
select-
this will form a part of the tender
Report.
conditions.
So,
So, where are you being left high and dry?
No.
Ask your retrenched employees if they manage to get into job, if the contractor appoints them, outsources them to ONGC, they will get the same benefit, but they will not get it from 2012. So why have you questioned it?
In the event of, I am not at all claiming it. That's the misunderstanding.
No, Mr.
Because I am
That's
not.
what tell us one thing. Don't ask us to answer. Now, what does this mean? In future contracts, this will form the part of tender conditions. What is it? What is this? It is an unnecessary, you are trying to create something, create a problem for you and then trying to shoot it down. What imaginary ghost have you seen? Take a call. During lunchtime, take a call. This is given. This is the terms of the agreement. Unless we have understood you wrongly.
The above wage.
Unless we have understood you wrongly.
because now they will be.
We will record that Mr. Das Gupta says that in all future contracts, this hike should be available. This is the terms of contract only. No question of interfering with the judgment of the learned single judge, which is absolutely correct. Read it properly.
No, Milords.
Again, Milords, we have read it out to you. In future contracts, this will be a part of the tender condition. Unless you read it differently, that this will be a part of tender condition, whether they would get the higher wage or not. Where are you getting this ghost from? And what you are, actually, this is not your case, Mr. Das Gupta. You had come before the single judge for a different issue altogether. Now that you have seen the views of the court, you have tailored your this is like a senior advocate.
No.
I mean, no, good. Question is that the terms of the conciliation agreement was made part of the award. Correct? Now, can 226 be used to
Only one thing, because I want to give some relief to the person concerned who were disengaged prior to 1/4/2000.
Correct. So they will not
And
get
I
any,
thought
they will not get any arrears. They will not get any arrears, even for the period that they served, because they are completely known entities so far as ONGC is concerned. This term of reference, this term of settlement is with respect to a limited class of people. Otherwise, they will say
then
that
what
we
for
would,
to come?
had we anticipated that so many, all those disengaged workers who have worked from 2012 and for some time or the other, they must get 35% hike. I
No,
think
no,
the entire
In the,
ONGC.
in the event of new engagement of contract
That is
labor,
covered.
So that is what we are asking you to read. I don't know why you're missing out on that.
the above wage
Because this
revision,
was not your case, therefore you're missing out on this. It was not your case before the learned single judge. Your case was that you be permitted, you as an association be permitted to hire those persons.
no, my Leonard Single Judge has quoted my
Learned single
prayer.
judge को छोड़िए ना, अभी आपका जो विचार है वो बताइए. Forget about learned single judge. We will deal with your case afresh,
Much appreciated.
regardless of the fact what has been decided. Now, how are you agreed by this?
My only thing is that in the
You rightly said that, Mr. Das Gupta. You don't have to skirt the issue. You want such persons also to be paid the hike, I mean the
in the
percentage.
event of engagement, re-engagement.
No.
Yes, yes.
In the event of engagement, so they will get
No.
wages which has been decided.
Not-
In future contracts, this will form a part of the tender conditions.
No,
In
but-
subsequent engagement of contract laborers by the contractor, they are bound to follow this award because it will be a terms of the contract itself, the tender document itself.
बहस
They
कहाँ
will be
से?
notified. They will be notified.
No, so
They will have to pay all.
I'm
this
again,
and
rep-
that.
I'm again repeating in before single judge, you argued something else. You argued that persons who have been, just a minute, just hold on for a minute. You argued that persons who did not continue beyond 2011, they were disengaged.
Yes.
But they must be paid for the period because
No.
they were engaged.
No.
This
that
was the argument.
That was not my argument. My argument is the person concerned who had disengaged. before-
Where has the learned single judge said that in a case of new contract with the ONGC?
No, Miller, one thing.
Where is that disclosure? Where is that disclosure in the single judge's judgment? Let us see what is your prayer in the petition.
Yes, my prayer has been quoted by my Lord Single Judge at page 197.
Internal page 19, ये तो ठीक ही है.
In the premises, of course, the petitioner prays that your lordship may be pleased to admit the petition for the record rule calling of the laborer who had disengaged.
Just a minute. Paragraph 9. In the premise aforesaid, the petitioner prays that your lordship may be pleased to admit this petition called for the records rule. Why the contract laborers who were disengaged prior to 1/4/2012? एक तो 1/4/2012 के पहले का disengagement का मतलब ही नहीं है. Shall not be engaged as contract labor in the event of engagement of new contract laborers as ensured by fair wage policy with respect to the contract laborers who were in the job as on 1/4/2012. And upon hearing, I don't understand. क्या है?
ये as per this prayer ये इससे आता है कि अभी जब नया कॉन्ट्रैक्ट होगा हम लोगों को एंगेजमेंट का एक साल का देन दे विल कन्वर्ट उसको एक री एंगेजमेंट का प्रेयर है.
तो री-engagement कहाँ यहाँ stop कर रहा है? This where is the question of
You want a re-engagement in case of future contract, isn't it? It is your prayer. So there is no bar under this
the bar?
policy or anything. They are also not saying that you will not be re-engaged.
There is no
Is the
bar.
contractor saying that you will not be re-engaged?
That much observation is sufficient.
No, but why do you observe? This is giving employment to you. I mean, which we would not be under our remit to give employment to everybody who claims. We can't.
Then your case may come under 25H.
25H.
Then that I was retrenched, no re-engagement was not given. That will be different.
This is a completely different issue.
this
This is you proceed ahead. Don't come for this declaration by court of law. Please, sir. देख लीजिए, I think we have correctly understood your malady. Don't press this any further. In fact, we will clarify that is a separate issue. आप करिए, go before the contractor, seek your employment. or file a case before the industrial tribunal
Tribunal, the 20
that you have been retrenched
Retrenched and-
without
Oh.
caring for section 25(8).
Yeah, we filed an application under section 33A before the industrial tribunal, but we had to withdraw this
But why did you withdraw?
because of the fact there is a clause in the settlement itself.
Uh,
Yeah, that is your lordship come.
uh.
The award.
Which page?
That is the unfair clause, Lord.
Hmm?
But we had to bound that by page 1 on page 50. Page 50. Clause. Page 61. That compelled us to withdraw this case. And then I have to approve before the High Court. Withdrawal of pending court tribunal case relating to the demand for regularization and revision of wages, considering the whole package of benefit which is to be ensured by the ONGC management to be extended to the contract labor deployed in their operation by contractor. It is again agreed with the above terms of settlement, the demand of the
No,
party.
no, no.
I think this
No, no,
should
it
not
is
bar you.
agreed that with the above terms of settlement, the demand of the workmen represented by the signatory trade unions.
Hmm.
So you should not have withdrawn that if you are individually processing it.
Otherwise, if we do not withdraw the settlement, the award could not
So
be
the
passed.
trade union agreed for it because it was a tripartite settlement. The trade union was part of the deliberations. You are asking for something else. That was an issue which is separate. Now you had gone. Did you go for retrenchment? Did you go for rehire? Did you go before the industrial tribunal for a rehire? No. You went there for a hike in wages in comparison and in consonance with what was being paid to other sectors in the oil
Yes, we filed an.
schedule rates. So that you withdrew because they gave you.
They give you and.
No, only after withdrawal of this, no, the award could have been passed.
No,
No,
withdrawal relates to
We can't
regularization.
make you understand that way. You please
Withdrawal
give a-
relates to regularization cases, not the cases for retrenchment and all. This will be an individual thing. Invention very well
Don't
pick up this.
you? In fact, you will be disturbing the entire schedule. The agreement is to give a higher salary to the employees, which would come to your benefit if you get employed. Nothing else can be
Withdraw
done.
above terms of settlement, demand.
Nothing else can.
Maybe
Take a call. In
trade
fact,
unions
in
for
fact, you should
registration of contract.
proceed. You should approach the industrial tribunal or ask for rehire. That's a separate issue.
Even their withdrawal will not burden because this relates to regulation of contract workers and revision of wage. So these two only.
Workmen represented by signatory trade union for regularization of contract
Contract
workers. You had not gone for that.
No.
You had not gone for
not
that.
no.
And revision
So-
of wages
so
pending.
pending.
So
Yes, that was the case.
yes,
No.
finished.
So.
So these are.
It was the dispute was referred before the industrial tribunal for fixation of wages. Now, in the meantime, and settlement was there.
That chapter is over. Now you are saying re-engagement,
Yes.
25H. Whenever these questions comes, this clause 6 will not bar you approaching those tribunals or seeking re-engagement.
Two aspects. देख लीजिए आप. We don't want to force you into.
No, not as a question, it's a question.
You
of
have the
giving-
liberty.
No,
Don't take an
it's a
order.
question of giving some relief to the workers and nothing else.
That's a liberty to you. You can do, but here we can't possibly pass an order. What the learned single judge has said is correct. इसको लिखा देना. Do we dismiss it the appeal or you withdraw it to approach the forum?
But you also pass such an order. no?
Yes. Dismiss. Dismiss.
In other case, look, dear lordship, only one point I want to like my lord, submit lordship. In other case, lordship, can you see the this 117 lordship in the award lordship? There is a close lordship. 117 lordship. That settlement.
Same award, out of
Yes,
same
Lord.
award.
Yes.
So we'll see
That
later.
settlement was for a period of 5 years lordship.
That's true.
That is already over lordship. Now.
Over. So now that doesn't operate for any
With
body
the
else.
permission lordship, there should not be bar to my lord re-engagement of the my lord, my lord. petitions, Lord.
It's no bar.
But
where-
My lord, he is the part of the union which had filed the first writ petition
was-
or the appeal.
Huh.
Now, during pendency of the appeal, he came out, some individuals who are part of that union and a signatory to this settlement came up and filed the second writ petition, and it is the second appeal. So the
Same prayer.
same prayer. So in my respectful submission, my lord, the second writ petition by the same people who
We'll not go into
Go
that.
into that.
We'll not go into that.
it is not maintainable in my.
We'll not go into that.
So my lord,
And
my
Prima
humble,
facie, this is not maintainable.
my humble.
In fact, the
submission-
learned single judge ought to have dismissed the petition on that score only.
My lord, my humble.
Not on the ground of this being part of the, of the industrial award and the agreement. There is no cause of action.
My lord, my humble submission, my lord, this clause, my lord, this paragraph, my lord, maybe my lord, part of the judgment lordship and.
Which clause?
My lord, page 117 in other.
Clause?
My lord, paragraph, yeah, what clause?
Uh-huh.
Paragraph in the, it is, may I read lordship for a moment?
Yes.
It is agreed by the unions and principal employer ONGC management there. These benefits to contract workers shall be extended through concerned contractor with effect from 1/4/2012, and this settlement will remain in force for a period of 5 years from the date of signature or till minimum wages for
It will be very difficult for ONGC to retract from that position. But this agreement is only for 5 years. You have agreed. It's okay.
Well, that is why I am submitting not to.
Can't extend the life.
As the period of settlement is over lordship,
Ah.
so there may not be any bar for my lord
that is
re-engagement under the new
issue,
contract.
That is a separate.
No, no,
issue.
If,
Where-
if that award is
No,
not
this
there,
is-
where is the
if
question of
you are-
implementation?
That was the
Sitting
prayer
in
in the
it.
writ petition.
These are two different issues with two different dimensions. You're trying to conflate it into one. I don't understand what is the logic.
That was the prayer before the.
I thought perhaps, if I were a lawyer, I would have thought that those who were engaged in 2018 or 2011, but they were disengaged before 2012, for that period, they be given the hike.
Right.
This is what you had asked for. This is my understanding. That cannot be given.
Our cases will.
Rest is your anticipation.
Not in employment when this agreement was signed.
Therefore, they say that they might not have been in employment, but they would be guided by it. So they would be guided by it because if there'll be a future work contract. So within 5 years, if they were taken into account,
That would have.
same thing would
now there is
continue.
no-
Otherwise, nothing.
no-
By this time, the government must have come with the fresh schedule. Anyway, we have dismissed the appeals.
I mean, the other writ petition, other appeal,
Give your appearance slip.
representing ONGC.
Yes.
I have given it.
All right, lordship.
Item 17.
Item?
Make these lordships, in this matter, learning the Advocate General will appear in this particular matter, who is currently engaged in some apartheid matter in another court, lordship. So, I'm praying for an adjournment for today, lordship.
Have you taken his consent?
Yes, lordship, yeah.
As prayed for on behalf of the state and agreed to by the learned council for the appellants. Let this matter come up for consideration August.
13 August.
दो तरीके से PM भट्टमतानी नहीं और PM भट्टमतानी और राम नारायण शर्मा का देखो
Lordship, in this case, Lordship, we have submitted one.
Which
compulsory
matter? The
judgments
one-
in
one-
17, item 17.
yes,
So shall I take it back, or Lordship will keep it in the
Keep it in the
record? Lordship?
let it remain on the record.
Yes, Lordship, much obliged. Today we have submitted, Lordship.
Item 18.
Lordship, what accommodations may be given, your lordship?
Why?
Since last 15 days, I am suffering from fever and cold.
Huh?
Your lordship may be taken up on Tuesday.
There's nothing in this matter, no? We just have to deal with the law with respect to, interference with the punishment. Primarily, yes, you may be right, but would it make any difference? Suppose some punishment lesser than compulsory retirement, what will happen? He'll get pension otherwise. In this also, we may not quite agree, considering Ranjit Thakur, Ganayuthan, Om Prakash, and Coimbator's case. This interference was not required, but it is not doing anything. I mean, it's not putting you to any
The bank case
unnecessary.
is quite slight difference from the other cases, your lordship.
We understand that. But will it make any difference so far as your responsibility as a payer, as an employer is concerned? Had he not retired, we could have thought of interfering with
He
the.
died in them.
He also died.
Died.
No,
No, he's alive. He's alive.
Retired.
No, but he is retired.
You will get your lordship relief salary in addition to gratuity. More than that, you will not get it.
Nothing. Then why do we interfere? But anyway, you have a right to argue, and we will have to straighten the record. The law must be stated in its correct perspective. That we shall do.
Lord.
When do you want it?
Your lordship may be given on Tuesday next.
Tuesday तो नहीं कर पाते कर देंगे पड़ा हुआ है. So we keep it on Tuesday
Lords.
as prayed for by the learned counsel for the
Bank.
appellant/bank. Let this matter come up for consideration on Tuesday.
Lord.
Tuesday का date दे दो.
16/6.
Traffic चला.
Item 19 and 20.
Your lordship, so in this matter, there is a subsequent development, my lord.
Mr. Mishra, there is a subsequent development.
I'm
We are
not
being-
aware. My junior is there, she should have given. I'm not aware, my lord.
In the break time only, Honorable High Court has
have a look at this notification, whether it suffices, whether it serves the purpose. So what we do is that, Mr. Mishra, your junior will provide you with this new notification,
My lord,
and then you shall argue.
my lord. As your lordship says.
Look here. The
But
learned
let
counsel
it-
for the learned counsel for the state has handed over a communication from the Commissioner of Transport to the Registrar Judicial and IT, Gauhati High Court, indicating that the Court of the Civil Judge Junior Division number 4, come JMFC, Kamrup Metro, has been designated as the virtual court for the state of Assam, which shall deal with and dispose of cases relating to non-compounding offences under the Transport Department. This does not actually answer the issue raised
No.
by you.
No, my case is about compounding offences.
Full stop. The communication further makes it clear that the virtual court system has been integrated with e-challan system of the Transport Department Assam and has been made operational. Mr. DK Mishra, learned senior advocate, submits that he shall recalibrate his arguments if need so arises on the next day. Let the communication referred to above be kept on record, a copy of which has been handed over to Mr. Mishra, to the junior, to Mr. Mishra in court. Mr. Mishra appears virtually. Let this matter come off. Let these matters, there's only one. Let these two PILs be listed for further consideration on which date?
My lord, after the vacation, on 20th or 21st.
Then we keep it in the second week of August.
My lord, as your lordship.
On 13th of August.
My lord. Obliged.
Item 21.
Yeah, please, Lordship. My senior was proactively looking for this, coming for this matter, but unfortunately he is.
He's seeking an adjournment on behalf of Mr. Purkastha.
Where is Mr. Purkastha?
He's
He's unwell, Your Lordship.
He's unwell
That's why he has not come.
on account of indisposition of Mr. A.K. Purkastha, learned advocate who has to address this court on behalf of the appellants. The matter is adjourned to sometimes in August.
18th August. Item 23.
In this case, they have filed an affidavit in opposition today. Copy has been served upon me here. Now it is not in the record.
Mr. A. Das Gupta, senior advocate. Mr. A. Das Gupta, learned senior advocate, submits that the affidavit in opposition has been served upon him only today in court, which he would like to go through before addressing the court. Full stop. If need be, he may consider filing any rejoinder petition. Full stop. For the aforesaid purpose, he seeks some time. Let this case come up for consideration on sometimes in August, 20th of August.
Item 24.
You tell me, yeah.
May I please, your lordship, kindly give me 5 minutes so that I can take out my files.
Yes?
Kindly give me 5 minutes so that
Yeah,
I can take.
please.
Hello.
इसको आज सुन लेते हैं really thanks.
May I please, your lordship?
Just give us 1 minute. Yes.
Lordship, I was railway servant. Then in the
Appointed on compassionate grounds.
yes, lordship, absolutely. What happens, lordship, in the year 2007, I've submitted the form after filling up the forms, consent forms before the Railway Consent Authority. After verification in the year 2007, I was given the appointment on compassionate ground. And thereafter, I've been given promotion, due promotion in time. Now what happens, your lordship? In the year 2019, that is after almost 12 years, major penalty charge sheet, charge memorandum has been issued against me with 3 serious allegations. First allegation, I would like to draw your kind attention, lordship. Charge sheet was issued on 13/02/2019. That is page number 111 to page number 125, annexure 1. Lordship, got it? Page number 111 to 125. I would like to draw the attention of your lordship in article, that is charges under article 1, that is in page number 115 of my WPC, instant WPC lordship, wherein I may kindly be allowed to read it out. This allegation is that the said applicant, the then Puel Khalashi, now train driver, so and so RPN, that is Rangapada, working under OME IC in Rangia, during the period 2007, after the death of late Kaliram Nath, maliciously produced him as a son of late Kaliram Nath, ex-trackman under SEC POA Lakhimpur, though he is the real son of Dhaneshwar Nath. That is, I have projected the son of late Kaliram Das as per this allegation, but I was the real son of Dhaneshwar Nath and managed the appointment as Puel Khalashi on compassionate ground in illegal way. Thus, the applicant, the then Puel Khalashi, now train driver so and so, by his above act of omission and commission, had exhibited lack of integrity and acted in a manner which is unbecoming of railway servant and has thereby contravened the provision of so and so railway servant discipline and appeal service conduct rules 1966. Now, lordship, thereafter, that is with the issue of this charge sheet in the year 13/2/2019, DP as quasi-judicial process has been initiated against me. Now, in inquiry stage, the inquiry report, that is page number 126, inquiry report, lordship, dated 14/8/2019, page number 126, 153, annexure 2. Lordship, I would like to draw your, wherein, lordship, this allegation was not proved, stating that what is stated in the inquiry report by the concerned inquiry officer. I would like to bring your notice to this annexure. 126.
Page 1.
126, lordship, kindly see. 137, I would like to.
Yes.
Yes, lordship, page number 140. By paragraph number 6.7.12. This is of inquiry report. From the above evidence, the document, it is revealed that the article number 1 has no substantial evidence.
You're at page 140.
Page number 140, lordship. Lordship, got it at the bottom level.
6.8.
6.7 and 12. Lordship, got it? May I
Yes,
read it?
yes.
From the above evidence that documents, it is revealed that Article 1 has no substantial evidence which could establish that Sri Lachit Nath, that is, I am the applicant, petitioner, is the real son of Dhaneshwar Nath. Rather, Sri Lachit Nath has some legal documents which he produced before, produced as defense documents during the inquiry.
So this is not in dispute that your son of Kaliram Nath.
It has been not proved.
Charge has not been.
Yes, charge gone. Now, lordship, this is very relevant. So far, Article 2, that is charges under Article 2, I may kindly be allowed to draw your kind attention in page number 115, lordship. The charge, I may be allowed to read it out, lordship, charge Article 2.
115.
Page 115, lordship. May I read it, lordship? That Sri Lachit Nath Dadan Puel Khalashi, now can driver working under DME, I say Rangia, during the period 2007, had given false statement that he had been appeared in HSLC from Dhakshin. This may kindly be taken into consideration, lordship. Dhakshin, Kalabari High School, and passed HSLC in the year 1992. Thus, I have contravened the provision of railway service conduct rule, so and so. This is one allegation which has been proved during inquiry.
Yes. You continue with your.
I would like to draw your kind attention towards the charges under Article 3 on the same page, that is 116, Lordship, bottom level. May I read it, Lordship? That I, so and so, the then fuel Khalashi, now train driver, C.W. Rangapada, working under DME IC in charge during the period 2007, produced a fake HSLC's admit card, admit mark sheet and certificate bearing roll number so and so, and managed the appointment on compassionate ground on an illegal way. So this is the contribution of the provision of my railway service conduct rule. So this article charges under
Come to 6.8 paragraph at page 140.
140, Lordship.
Read that paragraph.
6.8. Yes, Lordship. See, as per Article 2, Sri Rajitnath Dadan Fuel Khalashi so and so who had been HSLC Dhakshin Kalabari High School and passed HSLC year in the year 1992. Then during inquiry, PW1 stated that for verification of educational qualification, he has attended the Dakshin Kalabari Higher Secondary School. Lordship, this may kindly be taken into note. That is, what was my declaration as per the charges? I passed my HSLC, that is qualification, HSLC examination from the Dhakshin Kalabari High School. And PW1 stated that he attended the Dhakshin Kalabari High Secondary School.
Higher secondary school.
Generally, high secondary school में school class है दोनों both रहे कभी high school कभी high school में बोलते कभी high secondary class 12.
Yes.
From my end, I highly try my level best to satisfy this honorable court. First one is that I have passed the HSLC as per allegation as well as passed from Dakshin Kalabari High School. And PW1 inquired from Dhakshin Kalabari Higher Secondary School. No record reveals that both the schools were same. And I will come and satisfy. I was amazed to know.
6.8.2.
Lordship.
The other paragraph, continue reading it.
6.82. DD7 is the letter of significance sent for verification of genuineness of the admit mark sheet and certificate of so and so by vigilance officer to the secretary board of secondary education board so and so that is so and so clarified that the date of birth and result of divisions of mine of roll number so and so for the year so and so HSLC is false. Since the concerned authority has clarified the fact as false and defense has not put any substantial evidence against the PD6, which reveals that the article of charge 2 is substantiated. Now, second, as per 6.9, Lordship, as per Article 3, Lachit Nath, petitioner, managed the appointment on compassionate ground in illegal by producing a fake HSLC admit and mark sheet and certificate bearing so and so, and as such, it is discussed in earlier para that the date of birth so and result of HSLC admit card, admit mark sheet and certificate bearing roll number so and so of Lachitnath have verified by the board of secondary school and found false, and the principal of Dhakshin Kalabari High School where Sri Lachitnath claimed to be studied certified that Lachitnath was not a student of that school as per the admission or register and other relevant from records from the year 1991 to 2001. It is obvious that the certificates were very fictitious, or fabricated. As such, article of charge is established.
Any FIR law?
No, Lordship. No FIR has been lodged. And this case has really amazed me. I was surprised. Lordship, I will try to come to the fact.
More amazed. The laws and FIR now also.
Yes, they could have. But I was fortunate that no FIR has been lost during the relevant period of time. Now, Lordship.
Now also we fortunate then we close it here.
Now, Lordship, when I was appointed in the Railways Department in the year 2007, Lordship, so far my knowledge goes, when I fill up the form, after submission of my form, the concerned authority has verified after being satisfied who I was appointed. Now, Lordship,
where is the complaint which initiated all this inquiry?
That is the crux of the case. Lordship, during the quasi-judicial process, during inquiry proceedings, I sought for that document. When the PW whispered that after, this is very exceptional case, Lordship. When PW during inquiry submitted that after getting the complaint, I started inquiry and visited so and so schools, then other places, Count Buddha, that is village head, I obtained the certificate, all are in the part of the record. Then I obtained all these things. That means, which indicates that after obtaining.
Tell me one thing. Where is the certificate of your HSLC?
Lordship, I am.
Shows the certificate.
But the thing is
Shows
that.
the certificate. We'll have it in quiet
Lordship.
now. ऐसे हम लोग नहीं देखेंगे। इसको हम खड़ी करा लेंगे।
HSLC admit card is there, Lordship.
Where is the result? You must have passed 10th or 12th.
One. Where is that report in, is it report from Board of Secondary Education is a part of it?
Yes, Lordship.
Page?
Yes, 255. The report from the.
Page 255.
29, page 25. Page 255, Lordship.
False है लिखा हुआ है।
Where is the inquiry report?
Date of birth and age false, result division false. There is no record of you are having obtained. And which were the documents which were sent for verification?
188. 188.
188.
Yes, Lordship. Lordship, here.
Just a minute. This is the certificate that you had produced. You don't dispute this.
Which one, Lordship?
At page 188.
Answer
188, all are, Lordship,
No, we will proceed further. We will proceed.
Because, Lordship.
Mr. Das, your Das, no? Jyoti Prakash Das.
Yes, Lordship.
Now tell us, this is the certificate which you used at the time of your appointment.
No, Lordship, this certificate has.
The answer can either be yes or no. Then we'll ask for an explanation.
No, I didn't use this one because.
Which certificate did you use?
Whatever that is in there.
No. Don't say whatever it is. Then whatever it is, then we'll leave the judgment as whatever it is.
Lordship.
No, which is where did they lay their hands upon this document unless it were in the record of the employer?
I may kindly be appreciated, Lordship. First one is that the.
Mr. Das, you need to appreciate the bench. We understand. We have taken note of one argument of yours that these documents, where is the original letter of complaint? Who has given this? If he has not deposed, whether it would be taken as a relevant document, the person, the communicator, his deputy secretary in charge, Board of Secondary Education, he should have been brought as a witness. These are grounds which would weigh with us.
Yes, Lordship.
Only if we find that your claim is bona fide. The moment we find that it is fraud, vitiated by, everything appears to be fraudulent.
Lordship.
Just a minute. Therefore, we are asking you a question. Is this document at page 188, is this the document which forms part of your service record?
No, Lordship.
Then where is that?
This
Which
is the
document did you use?
So, Lordship, this document has been issued by the prosecution along with the charge sheet. This is one of the relied upon document.
No. When departmental proceeding had been initiated against.
That's why.
अरे आप मेरी पूरी बात तो सुनिए. The first answer of yours to any question should have been that what is this? This document has not been used by me. This is the document.
The list of documents इसको दिया था यही है. Certificate bearing number so produced by so at the time of appointment. This is the list of documents.
Therefore, where do you deny that? Where have you denied?
To satisfy this.
You don't have to fold your hands.
I'll reply all these questions. All the questions will be.
Where is your reply to this memorandum?
Reply is there. Lordship.
कुछ नहीं क्या मेमोरेंडम क्या है ये
ये सांस में नहीं ना इसको मेमोरेंडम
I denied that one, Lordship.
तो इसमें ये तो इसमें स्पेसिफिकली प्रोड्यूस बेसिकली
now where is that reply to the charge memorandum
13
dated 13/2/2019? Have you said that this document which it is not in record? I don't know which is this. You have brought it from somewhere.
Lordship, what my submission, humble
Submission we will here we will make
answer our queries fast.
Yes.
unnecessary.
Where
why
is your
should we get
reply
into?
to the memorandum? of
Just give me a second.
लाइए ना. Which document did you rely upon? Give us.
That is, Lordship, page 126(2). This is my reply. That you are advised to submit, dear inquiry was
ये fraud करके.
मिला मिला छोड़ो
126.
no what is this is NHC reply.
Where is 126 is nothing.
No, I was sought for reply. Dear inquiry, oh, Lordship,
इसको तो बोलना पड़ेगा ये डॉक्यूमेंट में नहीं लिया है
in inquiry report, Lordship, I
नहीं बोला मान लो कि वकील गलती
Lordship,
तुम
in
बताओ
inquiry
ना
report-
ये है कि नहीं तुम्हारा having a copy of the certificate which you annexed, which you showed at the time of your appointment? Original?
I will.
Where is that?
Form is there. One format was there of railway department that I have annexed. Format that, no.
Now
after-
this, where have they?
your matriculation certificate admit original shall be to you.
It was, what happens, Lordship? I've submitted.
You have submitted copies, not the original. Nobody submits all documents in original.
That format will reveal that I've submitted. I'll be.
Forget about format. Do you deny that this document at page 188 was not the certificate which was furnished by you?
Yes,
Do you?
Lordship.
Where have you denied that?
Because, Lordship,
Or because से क्या होता है? Where have you denied it?
the issuing authority was not examined. I was deprived of cross-examination, those things. Because.
We'll go to the cross-examination in subsequent stage.
Yes, Lordship.
There was an allegation that these are the documents, you have, these are fraudulent documents, so on and so forth, and these are the list of documents you are relying upon. Where is your denial? That this is not my certificate, you have taken it from
So that I can.
somewhere else.
We will not allow you to proceed further unless we are satisfied on this point.
Lordship.
All these legal grounds would be of no avail to you, sir.
Yes, Lordship.
This is everything.
That's true.
Oh, who is going to question? Where is the complaint? The person concerned, the in
Whole
charge.
case,
Just a minute.
whole case
We are
was-
not going to look into it now. Where the in charge secretary of the Board of Education, he has not been questioned, he has not been brought to the witness stand. I mean, he has not been cited as a witness. We will hear all this only when you say that this is not the certificate. Here is the certificate. I
satisfied
cried.
this honorable court.
Your answer should be, I cried hoarse before the tribunal. Tribunal did not give me an
But
opportunity.
you
Will you?
said, Lordship, kindly see that judgment where it is admitted after 19 years, my charge sheet has been.
We
and
will not go to any judgment.
punishing case is very much.
No judgment. You have taken reference of judgments of police officers who at that time, at some earlier point of time, they were involved. They did not say about this, and later something had happened. That the court
that's
says
the
that after
Lordship-
10 years,
Lordship-
12 years.
Okay,
Yes.
okay, give us your genuine certificate.
Which one, Lordship?
That original genuine certificate.
Lordship, I am.
According to you, which certifies that you have passed, which is genuine.
Lordship.
Admit card, metric admit card. And
We will have it examined by the board.
Board.
And in that case, we will direct for your prosecution if it is found to be false.
False.
Don't ask us to do all this.
My, if,
Can't deviate us from looking at facts which are apparent on face.
exactly.
If we go to
Sir,
that.
this is, I would like to draw your kind attention to the judgment, Lordship. Imping judgment, imping
Facts
judgment,
पता ही नहीं आप judgment की बात करते
imping
हो.
judgment, Lordship, imping judgment, that I have challenged before.
Impugned judgment we have seen.
Yes,
What do you
Lordship.
want to see?
Lordship, kindly see page 408. Kindly see, kindly.
अच्छा मान लीजिए judgment खराब है, गलत है, तो आप बताओ ना.
No, what is खराब इसलिए है, Lordship, क्योंकि यहाँ पे contradiction judgment दिया गया है. ये judgment खुद contradiction है, Lordship. Kindly see para 9 of the judgment 408. Kindly see. I may kindly be allowed to read it out, Lordship. Portion. Kindly see this portion. bottom level. Yes, it is an admitted fact that the memorandum of imputation of misconduct or misbehavior was served on the applicant after 12 long years. After 12 long years and during
हम
inquiry,
लोग क्या पूछ रहे हैं, आप क्या बहस कर रहे हैं?
Lordship,
Please answer our question. See, two options.
इसको ऐसे में बोलिए,
हाँ.
ऐसे में बोलिए।
Up, you give us that. Your certificate, will send it to board. If it is false, then next course of action will be a criminal prosecution.
Immediate
against it.
FIR and arrest. Because this would be duping the courts.
I'll bring.
You must be having original with you in your file. अब कहाँ उसमें देख रहे हैं? Mr. Das, the safer option for you is to let it go.
Oh. So,
The moment you question that,
Yes, Lord.
we will start our probe. And the moment we probe you and we find that it has to be examined by police, then we will be, our hands will be tied. We will not be able to exercise our sympathy.
Then prior to this, I may kindly be allowed one opportunity, Lordship, because I would like to draw your.
No, we will record this. One
This
opportunity we are not going to
this
forget.
certificate. No, whatever they have furnished, respondents furnished to me along with the charge sheet, kindly come to page 187. This is the RAD, relied upon document, Board of Secondary, issued by Board of Secondary Education, wherein my roll number has been shown as R7304. Whereas, yes, Lordship.
This is 259.
187. 187, Lordship.
Page 187.
Yes, Lordship.
ये और फंसते जा रहा है, वही बड़ा मुश्किल है. This is to certify that so and so roll number 7304259. Same thing. Same
Yes,
certificate.
Yes, Lordship. Here it is written R7304.
Huh.
And kindly see page number 252, Lordship. 252. What they have said,
वही है, same. पता नहीं 252 में क्या दिखा था.
R7.
ये तो और टेम्परिंग किया है.
304.
304 को 302 कर दिया है. This is tampering. यहाँ पर 304 लिखा.
Kindly come to 252 page. Annexure A.
Mr. Das, you will, instead of getting appointment to your client, reinstatement of your client, you will make him land in jail. 252 is clearly an indicative of the fact that you have forced everything.
Lordship.
And you tried to
that's
tamper
what-
with the records of the court.
That's why I'm trying.
We are only cautioning you, Mr. Das.
Lordship,
Please don't.
Lordship, kindly
Please.
see, this is the verification of genuineness of the certificate sent by the railway to the secretary of board.
We are not concerned with that. That time you may have.
Lordship,
they may
kindly
have to
see
be-
what is written. My roll number is R7302. They were directed to verify that one.
देखो.
And they have
यहाँ देखो ना,
verified
page 2.
307.
यहाँ पर है, इसको फिर बाद में.
See, this is absolutely contradictory, Lordship. This may kindly be appreciated, Lordship.
We are appreciating it in the.
They have verified 307.
इसको भूल गया कर.
Lordship, kindly see, this is roll number stating.
Aren't you understanding that nothing is going to cut ice? You understand my language, no? I can speak English and Hindi.
Yes, sir.
If you can understand any of the two, I'm very comfortable with both the
ठीक है
languages.
सर, कुछ भी हिंदी भी चलेगा.
Hindi भी चलेगा, English भी चलेगा. But English is perhaps you're not catching what we are telling you. Now, all this argument is useless before us. The moment there is an allegation of fraud, our antennas, they become very alert. Now, we see here that this is the school certificate which has been produced by you, and according to you, it was found to be correct at the time of your appointment.
Lordship.
This is the case of your employer. Says that it was only later that we made some inquiries and we found that it was all fake, fraud. And then the same very certificate, which was the photocopy of the certificate, which was deposited with the employer, their record, that was sent to the board. Now, there may be some mistake in taking the name of the school. It is either high school or higher secondary school or Dakshinbari or Dakshinari, we don't know. Now, this is the roll number because board is one, no?
Board is one.
High school leaving certificate and the as the education certificate, board is one. There can't be any difference.
Yes.
Now, this is the record and they say that it is absolutely false. There is nothing like this. And then you have shown page 252.
252 and 255.
252 is
And-
tampering. Roll number 7, just a minute. Roll number 7, 304, this has been made by overwriting 302. And the person who did it forgot to mention this roll, to make correction in the next, next few spaces. That remains roll number 304. The certificate here, room 304. This is the list which you got of roll number 4, R7. Original card.
254 lots.
250?
254, that was the original one.
ये क्या
254
है?
page.
North East Frontier Railway.
Where it is written, they have sent this one, roll number stating that roll
इससे
number
क्या करिएगा? ये तो लिखा कुछ
R7302.
original नहीं है. As such, you are requested to examine and send the genuineness. Past mark sheet R7302 number 259. फिर यहाँ है, along with admit card. देखिए दो admit card था. HSLC past mark sheet roll number 7.
Where is the mark sheet? Just now I have seen somewhere.
Mark sheet is located.
Just now I have seen.
Nothing is available in with the board.
Nothing is there. वो जो mark sheet है,
और 302 का तुम समझे?
हाँ,
Mark sheet is at which
Mark
page?
sheet, yeah, lordship mark sheet,
Original
in
mark
mark
sheet.
sheet also, there is some HSLC park mark sheet, that is R7302.
So where is the mistake?
Lordship,
So,
what was that?
show us your mark sheet and admit card simultaneously.
Lordship, what?
दोनों दिखाइए.
दोनों दिखा.
हाँ.
So from your this record.
Lord, दिखा. एक मिनट.
ये दो
This
का number.
250.
Mark sheet is 304. मान लिया 302. But admit card roll number is 304.
HSLC mark sheet is R7302, which they sent for.
क्या?
ये दोनों बनना है. एक में 302 कर दिया, एक फुल में नेक्स्ट 304 कर दिया.
है ही नहीं.
ये दोनों को भेजा एक ही नहीं.
दोनों में से कोई नहीं.
Lordship,
कुछ भी नहीं.
Lordship, may I please, Lordship? Lordship, Vigilance Department, Railway Department has sent the mark sheet stating that my roll number is R7302. And what the result came out, they have verified 304.
We understand that. Please show us
That's
the
the
mark
Lordship.
sheet and admit card sent to the board. Please show us that.
Mark sheet page. They have sent, Lordship.
Just the mark sheet.
59.
One.
59.
ये पूरा क्या पढ़ेगा? R7304. ठीक है.
ठीक है. And
But mark sheet is roll number 302.
admit.
Made 188. No, it is certificate. This is certificate.
188. इसमें roll number
188
कितना दिया होगा?
certificate.
304. यही इसका नंबर है.
हाँ.
ये जो 304, ये भी 304.
304 तो नहीं है ना.
ये mark
जो
sheet.
भी हो 302 लिख दे या नहीं लिख दे.
ये
but
304.
304
इसका नाम तो वही है.
वही है ना.
फादर का नाम भी वही है.
ये जो डिपॉजिट किया था उसको ही रेलवे ने भेजा.
गलत है.
हाँ.
It's not
So
available.
इसमें that is making no difference. 302 लिखा है, वो लिखा.
Original लिखा करना. You show us our your original mark sheet and admit card.
These mark sheets and admit card, they have furnished along with the charge sheet, Lordship. That's why when they have sent.
No, forget about their things are manipulated. We'll give you relief. Please show your originals.
Original.
We'll give you relief and send you somewhere. Please show us that.
Send it somewhere, okay.
Ah.
Lordship, but the thing is.
That is for sure.
First, Lordship, so far my little knowledge goes, this case has cropped up from the complaint.
Forget about that.
Complaint copy was not given, and this, since it is.
Please
related-
first show us the foundation.
Mr. Das.
You are a genuine person. You show us your original certificates. We'll send you to the place where you required to go.
Yes, Lordship.
These arguments are of no avail to you. Just take one example. Suppose Mr. Jyoti Prakash Das, you have been practicing in this court since when?
2006, Lordship.
Correct? Now you got
Including Supreme Court.
in Supreme Court also. But you must have enrolled yourself with the Assam Bar Council.
Bar Council.
Bar Council से registration कराया है ना? You have enrolled yourself. Now suppose at the time of registration nothing was seen and everything what you suggested was accepted to be true and they registered you as an advocate. After say 15 years somebody makes a complaint. Some fictitious person makes a complaint, not even a known person. Same as Devi makes a complaint that here is an advocate who is a fake person He has not even passed law. Suppose she makes that complaint after
That is the allegation.
after 12 years of your service. Then would we question who R Devi is? Or that she must go and depose? One, if that is the question, then no inquiry should have been initiated. But suppose an inquiry is initiated
Right.
on the complaint of not Miss Devi, but any other fictitious person who does not want to come in open. Correct. So after the inquiry, it is found that no, you have not even passed your matriculation. What to talk of law? All your certificate is false.
My lord.
Then what argument would
Yes, Lordship.
cut eyes? Tell me.
It's a very good question.
So first question, first satisfaction is your certificate.
Lordship.
Then we will look at every other.
Everything.
Lordship, first question, my reply will be, if she has filed any lodged any complaint against you, I am entitled to that copy of the complaint.
That will come later. We are repeating. We are repeating the same thing.
I have been deprived of that or natural justice.
We are saying that whatever certificate they have sent, all are not correct, fake.
Yes.
Give your original.
Lordship, that will come. That will come.
Give us. Before that, we will not even give you any hearing to you. Please. Then we'll do whatever is required.
You do one thing. We will record that Mr. Das has agreed to give his original mark sheet and admit card, which we intend to send to the board for proper examination so as to appreciate the arguments advanced by Mr. Das.
No,
Correct?
Lordship, kindly, before that, Lordship can pass any order. I will just abide by that one. I'm compelled, duty bound.
आपको इतना देर सुप्रीम कोर्ट में तो सुनता नहीं.
नहीं, so on the, what is the illegality of the impugned order? That will be heard in Supreme Court. And here also.
Now we are not even looking at the order. We are not looking at the complainant. Where is the complaint? You did not get original. We want to help you out.
Lordship.
We want because you have obtained appointment on you have been appointed on compassionate grounds. Therefore, we would like to salvage your appointment.
Lordship, for a moment, can I draw your attention?
Can you give the original to us?
To a document, to their document, not mine. To their document. For a moment.
We'll not see.
Because when I sought for.
See, we are with you. A person whose certificate is genuine, but they have wrongly deprived you. Okay? Please listen. Please listen. So therefore, we will get ourselves verified and we'll ask them to reinstate you with all back wages. Otherwise, we'll send you where you should be. Prestigiously.
I may kindly be appreciated, Lordship.
Now we dismiss this petition and let you remain a free man on this earth,
Lordship,
or you want us to make further inquiry.
Kindly for a moment, Lordship, because this is related to service, Lordship, and 100% absolutely natural justice has been violated. Or dual term part.
We are giving you the natural justice.
During quasi-judicial.
So as the certificate.
Lordship.
The more you argue, the more our feelings get concretized that this is a fake case. आप ऐसा करिए ना.
Lordship,
You can.
Lordship,
We are giving you a passage.
Can I submit my humble submission? When I submitted that, give me the documents that I have submitted to the railway at the time of my compassionate appointment or prior to this. Kindly furnish me.
According to them, this is the document.
This is an old pending case. Docket is not available.
हमें आप दे दीजिए original अपनी. लिख दीजिए. We will get it exact. We will avoid all these.
I have to take instruction from my clients. For that.
Then we have to.
I'm not the custodian. I'm not the custodian.
You're not the custodian.
Yes, that's why.
But we will record your undertaking that you shall produce the original mark
I'm to
sheet.
take instruction for another date.
For production also.
I'm to.
Then we will discuss
obtain instruction from you. That's why. If I'll get, obviously.
Okay. You're a regular practitioner.
Yes, Lordship.
Are you a regular? We are concerned because of the advocate who is appearing before us.
Highly obliged.
You're not understanding, but this is good enough ground for us not only to dismiss but direct for an investigation by the police. And then we can also have a complaint registered against your client for furnishing false evidence before the court.
Lordship.
And that would be governed by section 340 of the old code.
Your Lordship has enormous power. But what is my...
We don't want to exercise that power, but why are you insisting?
No, Lordship. My humble
We will
submission is that
deal with the
during
matter
proceedings
in a most non-abrasive manner that which will not harm you. We will only affirm the order of the tribunal. That's all.
Otherwise,
For a moment, can I bring your lordship to this paper? For a moment, lordship. For a moment.
ऐसा जिद-
Lordship, kindly at least extend this opportunity. For a moment.
you are inviting,
Yes, lordship, I got it. You are to help. And my legal duty is to extract out the fact.
your
Yes,
legal
sir.
duty is to also to think of your client.
Yes, lordship. Yes, lordship, I got it. Kindly see, lordship.
Don't feel like you are scolding. You are a regular practitioner of this court, no?
Lordship,
You regularly practice in this court.
everywhere, lordship.
No, here you are not
Here
regular.
also, here are a lot of cases, 17 cases pending. Page number 250.
You will not go beyond that.
Page number 250.
First,
kindly.
please cross the first hurdle, then we'll.
This is the last time that we are referring to the
Yes,
pages.
250 kindly.
Hmm?
250 lordship. Page number 250.
ये तो कोई माल तो आज तक देखा ही नहीं था.
And where I denied lordship into page 265 against the charge sheet, 250. What is said here,
The
lordship?
docket case is not traceable तो English भी नहीं समझना है मैं क्या
Yes,
करना चाहता हूँ.
lordship, when I sought for the complaint,
जो सबमिट किया था उसको मुझे दो.
they have started the investigation on the basis of complaint. And when I said that when the complaint is there, my whole docket is not available with them. They say, this is an old pending case of 2006. All dockets are unfixed.
That's why you give us your original.
Original है ना? Where is
Then-
your?
They could have sought
No,
for.
no, you give us.
So give me some chance so that after instruction, obtaining instruction, I can satisfy. Give me another date, Lord.
कुछ लिखाएंगे तो आपकी परेशानी हो जाएगी.
लेकिन sir,
Any other
इसमें
court will
100% nature
any
just
other court
decided हुआ है.
will take action against you. Unnecessarily, you are inviting trouble for yourself as a lawyer.
Yeah,
There is a limit beyond which you can't defend your client.
Justice or reasonable opportunity पूरा violate हुआ sir. Lordship. During quasi-judicial process, I've been deprived of natural justice.
वो तो समझा. That we agree.
उसको तो chance भी दिया. Natural justice भी
Which is sufficient.
तो अभी तो हम लोग दे रहे हैं chance. We are giving you the chance. But लिखा है ये तो गलत हो जाएगा. You will face.
dismiss कर दे इसको.
छोड़. We give you time. We are not writing anything. Only for your safety, not for the safety of your client. If we record our findings, no, then you will fall in trouble. We don't want, never in my life, for 12 years of my judging, I have caused any damage to any advocate. Never. And I don't want to break that tradition, break that, record by coming here.
But
Don't do this. I am only adjourning the matter for August 10th or September. Do whatever you feel like.
September, Lordship.
September. All right. As prayed for on behalf of the petitioner, let this matter come up for consideration on sometimes in September. You advise your client, don't pursue it. This is after we have passed an order, we are giving you an advice. It is a clear case for police investigation. Certainly you will land yourself in trouble. Or if it is not so, and you are very sanguine about your genuineness, you bring us the original documents. We will forget everything.
Lordship, I'll try my. Because I'm not the client, so I have to obtain instruction from my client.